Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green bars lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello. Welcome back, everybody. Good to see you. Well, hello. I think you guys can hear me. Yes. Check in 1 2 3 1 1 1. Yes, you can. Awesome. Everyone has made it. Don't forget to press the like button on your way into your new seat. So let's start the old Wolfgang thingy. Well, we can watch from exactly where we left, but zoom through the thing. But I think it's gonna fail. But yeah. Oh yeah, Robert. I'll definitely teach you later, my friend. Not the problem. All right, let's go and let's get started without wasting any time.
Let's go to count one. Let's go to evidence of murder. Actually, and that applies to count one and count two. What then gives the support for the details of the murder? The details of the day of the fire are very inconsistent. You can look at her statements. She tells multiple stories about how she exited the residence. She tells multiple stories about what she saw. She tells multiple stories about why there's marital discourse, but denies that she's having an affair. She only gives the details she thinks won't incriminate her. You can also look at the reason for driving the van into the yard, which makes no common sense. She drives to an area worse off than that inclined driveway. The inclined driveway, that fire trucks are coming down, emergency vehicles are coming down. You saw pictures of it the next day. She drives to an area worse off than the driveway. She drives to an area that's more difficult traction, down a hill. She claims to be trying to get help, yet she drives into the backyard when Mike and Connie are driving down to her. She's in the driveway when they see her. Tracks in the yard show the van going from where Todd was laying in his pool of blood to the backyard. Claims to not know she hit Todd, yet the blood is all on the driver's side. There's a reason we talked about that in voir dire. You guys gave descriptions of what you heard when you hit a squirrel, a raccoon. This is all on the driver's side, and there's 7 points of impact with Todd's blood. She claims she didn't know she hit Todd, yet blood's all over that driver's side. And once she claimed, maybe in an attempt to try to cover her tracks, to one person, that she got out and leaned Todd against the bumper of the van, and that's why blood was present, which is interesting, because he would have had to have been bloody before she hit him and then leaned him up against the bumper in order for that blood to get there. What else can we look at for evidence that it was a murder? You can look at the evidence that Jardita Gordon gave you in her testimony. Linda admitted to striking him with an object during an altercation. She admitted to starting the fire with gasoline. She knew Todd was on medication. That's an odd fact for somebody at the jail to know without directly being told by the defendant. Todd suffered multiple lacerations that can easily be explained as a result of being struck by a blunt object. There's one completely in the back of the head. There's one on the top of the head. There's two on the sides. One could easily be explained by a blunt object. Perhaps even the frying pan that you see in the rubble that was not above, there was no kitchen above, and it was found in the laundry room. She admitted to wanting Todd gone. You can consider that evidence. She concocted ways to kill Todd. She thought about running him over and said that to Kate Fox. She thought about shooting him with a gun. That's why Kate called the police. She'd become violent with the boys. You can consider that. When confronted with inconsistencies, she became physically violent with the boys when they pressed on her inconsistencies. She coached the boys on what to say. Why would she have to coach them on what to say? She told them what to say at interviews, told them what to say to the police. She'd only do this. She's trying to hide the truth. Why didn't she just tell them, tell the truth, tell what you know? Why'd she coach them on what they could say? So let's look at evidence of premeditation, because that's count one. You gotta find evidence of premeditation. First thing, purchasing gasoline. You can consider for all these different things. You can consider for the arson, you can also consider it as evidence of premeditation. She gets up in the morning, she buys gasoline the morning of the fire. Cindy sees her, putting the hose in the rear of the hatch. Only logical conclusion, she's filling a gas can. A 1 gallon gas can is found at the front yard at the time of the fire. Tells Kate Fox she wants to kill Todd. She's thinking about it. It's premeditation, thinking about it. She contemplated differing ways of completing the act. She attempts to frame Todd. You can consider that. She uses Todd's credit card to purchase gas. She claims she didn't have any money, which I read to you, which is why she used a debit card, but yet she has $202 in her wallet in cash. Why is she using Todd's credit card? She wanted to look like Todd was the one that bought the gas? She consistently tried to paint Todd in a terrible light, despite having no evidence to support her accusations. Blame shifting. You can consider that as evidence of premeditation. You can also consider that she sent the boys away from home. She's thinking about it. Why did she send them all away? She told them to call first before coming home. She didn't let them see their dad. She physically blocked them from seeing their dad. Keys were waiting for him in the Blazer. What else? Her purse. Her purse and her money were found in the van. Corey specifically remembers that purse on the counter when he came up the stairs, said he was looking right at it. Linda was preparing to be gone after that fire started. That's the evidence the morning before the fire starts. But you can also consider additional premeditation. She sees Todd escape the burning residence. He's screaming, pulling off his clothes, hollering in the yard. She can't let him survive. He's going to tell what happened. So what does she do? She gets in the van. She makes a nice little arc pattern to the north side, into the backyard, and runs him over. She strikes him on the driver's side, directly in her line of sight. And she tells you multiple times, I saw him in the yard, then I got in the van. She saw him before she got in the van. And what did she do? She drove immediately and drove over him as Mike and Kanye are coming up behind. That's the second instance of premeditation. You got the premeditation in the morning about the fire. Now you got the premeditation of trying to run him over when he escapes. But now let's talk about the third time and her attempt to try to silence him when she doesn't kill him after she runs him over. He's breathing. His heart is still beating. He's struggling to breathe. His mouth is moving. And what does she do? She jumps on him, face to face, on his burned body. She places herself on his body, covers his face with her hands, by one witness's description. She has to be forcibly removed by people who are trying to help him and render aid. She knew he was struggling. She knew he was hurting, and she laid on his body. Why? She's thinking about, what if he talks? What if he lives? Judge is going to give you an instruction. We don't need to prove motive, but it's something you can consider. It's not an element, it's not a box, but it's certainly something you can think about. What could be the motive? Well, you got finances, cash strapped, behind on bills. Todd's lazy, doesn't work enough, doesn't make enough money for her. Divorce isn't going to benefit her. At the time, she has multiple horses. Horses are very expensive. Without money, you can't care for them. Without land, you can't care for them. Divorce would have likely have ended up in a place she wouldn't have had a place to keep her horses. Her obsession. Let's talk about Chris. She has been engaged in a 6-month relationship with a man she wants to be with. Best lover she's ever had. Wants to be with him. It's a long-term affair. Ends up going at least 8 months before she breaks it off with him after the fire. Let's talk about common sense. I told you, don't check your common sense at the front door when you come in this courtroom. Let's talk about why Linda's story makes no sense. She's involved in a terrible argument with a man she claims is abusive. Yet, she goes to the store and she makes him breakfast, builds him a fire because he says, hey, it'd be a good day for a fire. Yet gets him juice when he asks. Yet she putters about the house. Yet she puts Christmas decorations away. She reads an Acme pamphlet and takes a nap. Yet sends her children away from the home and her main source of transportation on the day she's supposed to be moving to her sister's. They're getting ready for such a huge fight. They're splitting up all their assets, send the boys away because this is going to be so horrible. And she's making breakfast and putting Christmas ornaments away and taking a nap. Why didn't she just pack and leave? It doesn't make sense. Why did she drive the van in the manner that she did? She claims she drove the van to get help. Yet help is coming down the driveway, the very help she said she's getting ready to go get. She's going to get Mike and Connie to help. They're coming down the driveway. Why? Why is she driving to the north side of the house when help, the very help she wants, is coming down the driveway? She claims to not have ever seen Todd in the side yard. Yet she strikes him on the driver's side, going at what we've heard may be slow speeds. She lines up and hits him on the driver's side. She says it was so smoky she couldn't see him in the yard. Look at the smoke, ladies and gentlemen. There's no smoke in the side yard. Certainly not obstructing her view in the side yard to see. You can see the trees in the background. Common sense says if you got outside, you saw your loved one escape that house on fire, Common sense says, "Oh, I probably better go and try to help this person, because by the time I drive down to the neighbors, how many feet away, this guy's gonna be burned up." Common sense, okay, let's say you panic and you don't think that way. Common sense would be like, "Oh my goodness, my husband, the father of my children, is on fire." You keep your eyes on him to see what's happening. She says, I see him when he comes out, he's on fire. But then she claims, then she didn't know where he went. Doesn't make any sense. Why she drove on the backyard? She claims it was to get better traction. Testimony established this was not an improved driveway. You saw the pictures. You can have them back in the jury room with you. Traction in this area is way worse. Going down a hill. Think about your grade, your basement. Even if you have an 8-foot ceiling, you're going down 8 feet. Claimed she did this to get to the neighbors. Yeah, the neighbors are already there. So let's talk about what does make sense. What leads from one conclusion to another. The morning of the fire, Ms. Stermer gets up. She's contemplating the fire. She goes, she purchases gasoline, and she removes the things most precious to her from the home. Probably, makes sense, she was arguing about her affair with Chris Williams, with Todd. She strikes Todd with an object sometime during that altercation, just like she told Ardita that she struck him during an altercation. And now you've got a possible laceration from blunt force trauma on the head. Dr. Markey testified that you can knock somebody unconscious without having any brain trauma, that just having that indentation could knock somebody unconscious. Also makes sense that she had planned to drug Todd with a cup in the dishwasher, but she changed course. Maybe that argument got out of hand. Maybe she just changed her mind and decided this was an easier way. She douses Todd with that gasoline that she bought that morning. So gets it on his underwear, socks, sweatpants, recliner. And he's not on fire yet. She runs downstairs. We don't know. She's changing clothes. She's letting the dogs out. Did she ever run downstairs? We don't know. If she does, we don't know why. Maybe she's changing clothes. She doesn't expect the fire to erupt as quickly as it did, because she doesn't know it's the vapors that were testified to that can ignite. You have an incapacitated man with gasoline on him. You run downstairs to grab something, do whatever you're doing, those vapors ignite. It would explain why it's sudden. It would explain why it catches her off guard. Who knows? Maybe she planned on going up and knocking a candle over. Maybe she planned on throwing in a match. It just happened too quick. Those vapors ignited. You've got that open source of flame, that fireplace, and it just erupted before she's ready. She flees the house. Here's the top of the stairs, as she describes it, and as Corey describes it. She gets to the top of the stairs, there's the counter, right where her purse is, right where Corey described it. She grabs her purse in an attempt to escape. Maybe she thinks she can just get in the van and drive away, he'll burn up. She'll have an alibi, she's not at the house. She's just gonna drive away. Problem is, Todd escapes. She sees Todd. He's in the side yard, ripping off his clothes, screaming. At that point, she's thinking, he's alive. He's got to be silenced. What does make sense? She gets in that van. She's trying to flee. She sees Mike and Connie coming down. Now she really panics. She can't leave this burning man in the north side of the yard, hoping he's just going to die, and she could drive away. Now she's been caught. She's been caught by Mike and Connie. What's she going to do? She going to take the chance that he's getting that fire out and going to tell Mike and Connie what happened? She panics. She pulls off the driveway into the rear yard. She lines Todd up with the driver's side and she runs him over. And I want you to think about relating that to all the stories she told Willison and Shinsky. Those are so elaborate. Driving, getting out, trying to help. He won't lay down. I get back in the van. I then drive, then I get stuck. Didn't happen. No time. Connie and Mike saw her right in the driveway. There was no time for any of her elaborate story to occur. There's no time. What does make sense? Todd gets out of the house on fire. She runs him over. She runs over to him. Oh my gosh, he's still alive. He's breathing. His mouth is moving. Now what do? I'll tell you what she did. She made another attempt to silence him. She jumps on a man who's struggling to breathe, placing her hands over his mouth. In yet her third attempt to make sure he can't talk and tell what happens. Using your common sense, that makes sense. The facts as told by Ms. Stermer make no sense. Then you often look at the cover-up. She tells multiple half-truths. We talked about half-truths in voir dire. We talked about what you do when you have a half-truth. She gives half-truths about the events of the day. She gives multiple versions of the events. She changes details surrounding the cause of the argument. She can't even keep straight what door she goes out of. She becomes physically violent or emotional when she's confronted with inconsistencies. She coaches her sons on what to say. More questions lead to differing stories. This is because, ladies and gentlemen, she can't tell the truth of what happened on January 7th of 2007. Because the truth makes her guilty of premeditating that murder, of trying to kill him in an arson, and ultimately his death. She wanted to make sure Todd was dead that day, and she wanted to make sure she did everything possible to make sure he did not survive. He didn't survive the house, he didn't survive the van, and he didn't survive even laying on that ground. She did whatever she could. Ladies and gentlemen, common sense. These boxes are checked. Linda Stermer caused the death of Todd Stermer. She intended to kill Todd Stermer. Her intent to kill was premeditated. You have all kinds of evidence of that. And that killing was deliberate, meaning she thought about it, she weighed the pros and cons, and she made multiple actions, confirming that that was her intent. She had time to think about it and change her mind. She didn't. She caused the death of Todd Stermer. She had one of those three states of mind. She either intended to kill him, intended to do great bodily harm, this is count 2, or she knowingly created a very high risk of death, knowing that that death would likely be the result of her actions, and that when she did that act, when she caused the death of Todd Stermer, she was committing or attempting to commit arson. Those are your elements. Ladies and gentlemen, common sense tells you those boxes are checked. You have all of the evidence. You have everything for that logical conclusion. I'm asking you, ladies and gentlemen, to go back into that jury room, go through that evidence in more detail that I've given you. I've given you a snippet over the 3 weeks that you've been here. I tried to sum it up for you. You have more. You can review anything you want back in that jury room. Look at that evidence, piece it to those boxes, and I'm asking you to find Linda Stermer guilty of both count 1, premeditated murder, and count 2, felony murder during the commission of the arson. I appreciate all your time and attention. Thank you.
Mr. Mueller?
Thank you, Your Honor. Give me just a second for a little housekeeping.
All right, I'm gonna interrupt a little bit because after this they went on break, so I am just gonna try to find when do they come back. So it starts his thing, so we can jump a little bit. There we go. Right about here.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. This is our last time to speak with you. Prosecution has the burden of proof. We'll go into that. That's why they get, in a case like this, the last say. This is the only time, excuse me, that I get to speak to you. I want to thank you on behalf of Linda Stermer and our team for the attention you paid throughout this case. Everybody took notes and asked question after question after question. So I know you're paying attention, so thank you. I want to tell you a little bit about your job. When you go back to the jury room, you actually have 3 jobs back there. One, obviously, is to decide the facts of the case and how they apply to the law. The second job you have is to make sure that everybody on this jury follows the law. When I say follow the law, when you were sworn in and we selected the jury, a lot of questions about the presumption of innocence, the burden of proof. As Linda Stermer sits here today, she is innocent. As Linda Stermer, when you go back into the room, when you walk through those doors, she is innocent. That is a solemn oath you took to hold that throughout this case. The third job you have, when you go back there, is to explain your position to the 11 other people on the jury, how you saw the evidence, what you thought about, how you considered it, and to also listen to them fairly and make sure that everybody gets their word. When you follow the law, what I'm saying is you have a right as a juror to make sure that when you go home after this case, everybody followed the law. Nobody bullied anybody else into trying to cave their opinion without following the law about presumption of innocence and the high burden of proof beyond a reasonable doubt. You heard Ms. Zutterbein speak for an hour and a half, and I timed it. She spent 5 minutes on the fire and the cause of the fire. So let me tell you what this case is not about. This case is not about a van impact. You heard Dr. Markey on the witness stand. Dr. Markey and Ms. Zutterbein said what she thought Dr. Markey told you. The one thing that Judge Brickley will tell you is what we say here is not evidence. What you heard from the witness stand, that's evidence. That's what we consider. And I'm sure Ms. Zutterbein didn't intend to misrepresent anything, but she didn't have a transcript of his testimony like I do, like we purchased. So I want to tell you what Dr. Markey said in terms of the cause of death. On page 19, Dr. Markey said to a question, my question, well, let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries. Fair? Said yes, I believe his death was caused by the thermal injury. Dr. Markey's opinion is the official medical opinion in this case. It's undisputed. And the government, the state, with all its resources, couldn't find another doctor in the state or in the country to say that the van impact had anything to do with Todd Stermer's death. It was solely caused by the fire. And Linda Stermer has not been charged in this case with anything having to do with a vehicle impact to Todd Stermer, not even a misdemeanor. So what does that tell us? One, the van didn't cause the death, and the van certainly didn't start the fire. Why did they spend so much time on the van? Well, I'll tell you. Because they wanted to distract you from the fact that they have no evidence of how the fire started. This case, ladies and gentlemen, the charges are first-degree premeditated murder. As Irving showed you, the jury instruction went through a whole bullet PowerPoint. Boiled down to, Ms. Stermer intended to kill her husband, thought about it for some time, and then carried it out. But the carried it out part is she's charged with felony murder. The felony is arson. So if there's no arson, there is no crime. If there is no crime, there is no premeditation. And so when you consider what you need to do is look at two things. Was the fire intentionally set? And if it was, did Linda Stermer set the fire? Those are the simple issues in this case. The burden of proof for the state is extremely high. Let's talk about that. Burden of proof is beyond a reasonable doubt. Reasonable doubt, ladies and gentlemen, simple terms, is doubt based on reason and common sense. If you have any doubt, as you look at all the evidence today that I'm going to show you and summarize the evidence, if you have any doubt that doesn't require you to abandon reason, then that's reasonable doubt. And what is a doubt? Well, remember I explained it with Mr. Leroy. To lack confidence in, to not trust. That's doubt. Here's the burden of proof, ladies and gentlemen. In a criminal case, the burden of proof beyond a reasonable doubt is the highest burden we have in any kind of case. And the reason is because when the government is going to take your freedom, our founding fathers made sure that they couldn't just say, we don't like you, we think you're guilty, and we're going to put you in prison. So what do we do here? Let's look at this. Is there a slight amount of guilt? Not good enough. Is she possibly guilty? Did she possibly set the fire? Somebody says that, you say not good enough. I've done a lot of civil cases where people sue for money, car accidents, product liability. In a civil case, the burden of proof is a preponderance of the evidence. Is it more likely than not that we believe Wolf's side or the other side? Kind of people like to say 51% versus 49. If it's 51%, more likely than not, then plaintiff prevails. That's not this case. Is it probable? Somebody says, I'm pretty sure, I think she probably did it. Not good enough. So when we talk about, as you go back into the jury room, what your lens is, these are the burdens, the things you need to consider. Very probable. I think almost for sure she did it. Not good enough. Now here's the other thing. In a civil case, the highest burden we have in a civil case is called clear and convincing evidence. That's not good enough. What does that mean? So when you go and address each other in the jury room. Clear and convincing evidence under the law is to be clear and convincing. The evidence must be strong enough to cause you to have a clear and firm belief that the proposition is true. Not good enough. Somebody tells you in the jury room, I really feel she set the fire intentionally. Not good enough. If you have any doubt as you look at the evidence that is supported by reason and common sense, no matter how small, that's reasonable doubt. And your job as a jury is to return a not guilty verdict unless the government, unless the state meets that high burden, exceeds beyond a reasonable doubt. Your job as you go in there, unless they do that, is to return a not guilty verdict. The other presumption is the presumption of innocence. Morano will review the law, and the law says this. We start out with the presumption that where there's a fire, the law assumes that it had a natural or accidental cause. The prosecutor must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. So you start with the presumption that's an accident. So that's the lens you need to look at as you go through this case. You know, before we started, one of the jurors asked, why would this case take 3 weeks? Should it maybe take 2 weeks? Because after all, it is only an arson case. Todd Stermer died of a fire. So you just have to decide whether the fire was intentional, and if it was, 2 issues, did Linda Stermer intentionally set the fire? Instead, what you heard, and I counted the witnesses, 20 witnesses over 1 week, to talk about the van, to talk about infidelity, to talk about other issues. And why? Because the state wanted to distract you and distract you from your job, which is simply to decide, was this an intentionally set fire? And it's interesting, In opening statement, and I had that, everybody took good notes, I'm sure, so you'll be able to go back to opening statement. The prosecutor never said what caused the fire. And here, after 3 weeks, Ms. Zuderveen spoke for an hour and a half and spoke for 5 minutes on the fire. And the best she could do is say that Scott Leroy said the fire was consistent with being intentional. You don't get a conviction based on it would be consistent with being intentional. Experts, as we'll talk about, are held to high standards. There's no guesswork in experts. You don't get to speculate. We'll talk about speculative opinions that Mr. Leroy had and possibilities. You heard from every legitimate expert in this case, starting with the MSP chemist, Troy Ernst. We don't engage in speculation. Speculation masqueraded as an expert opinion is misleading. So that's why we don't do that. Your decision must be based on the evidence. The evidence that is clear, credible, and compelling factual evidence, not speculation and guesswork. So when you deliberate, you start with the assumption and the question, assuming Linda Stermer did not set this fire. Did the prosecution meet its burden of proof beyond a reasonable doubt for every fact it needs to prove to meet those elements, those boxes that she talked about? And if they can't rule out reasonable doubt, if they can't rule out alternate causes, if they can't rule out alternate theories, if you can't rule it out, that's reasonable doubt. And we'll talk about that as we go through this. It's got to be based on the evidence. You know, one thing we heard when you were being selected, and you'll remember this, Ms. Zuderveen, when she was asking you questions, asked you this. It might take, to present all the evidence, we might be here for 2 months. So will you give us a pass? Will you not hold it against us if we don't give you all the evidence? You're darn right you have to hold it against them. They have the burden of proof of bringing all the evidence they have to establish guilt beyond a reasonable doubt. They don't get a pass, and you can't give them a pass because they didn't bring you evidence. We'll talk specifically, but I do remember one thing I wanted to bring to mind. There was that video, remember Deputy Gruss did the in-car video, and they showed 10 pictures over 9 seconds. One of the critical issues in this case, as you remember, is how fast was the fire, the speed of the fire, the direction of the fire. 10 stills over 9 seconds. I asked Deputy Gruss, what happened to your video? I don't know. Don't you think it might be better, since we're talking about speed of fire and direction, if we had the video, would that help? Yeah, that would help. But they didn't have it. So they can't help you with a critical decision in terms of the speed and propagation of the fire. So when you think about evidence that they say they don't want to show, that they don't have to show, can you give us a pass, don't hold it against us, you hold it against them. So why is Linda here? Why is Linda Stermer, after 18 years sitting in the defense seat? Well, how about there was a house fire, and as soon as the police got there was a man who died, and then there was blood on a bumper. So they rushed to judgment and automatically assumed someone's dead, someone's alive, blood on the bumper, has to be a crime. And you remember Sergeant Leroy, when he arrived on the scene, spent a lot of time telling you about the pictures he took about the bumper, because he suspected it was a crime. He took more pictures that night of the vehicle than he took of the house. He is the state's origin and cause expert. This became a rush to judgment with no evidence. In fact, what it really was, as you will see, this was the prosecution looking for a crime, because they worked backwards. Why do you think Ms. Zuderveen spent the majority of her time this afternoon, and the majority of the case, talking about infidelity, talking about having romance and best sex ever, and wanted to run away? Nobody said she wanted to run away with somebody. Chris Williams didn't say that. You can look at your notes. No, they wanted to show you the why, the motive. Remember, she said, we don't have to show you motive, but they spent the whole case and the whole afternoon talking about motive. Because they wanted to show you the why, so you wouldn't focus on, how about the where? How about the area of origin? And more importantly, how about the how? Because they can't tell you how the fire started. Sergeant Leroy, when you go through your notes, and I'll summarize it, you will not find anything where he said he could identify the cause of the fire, how the fire started. And if you can't identify the how, and even the where, then you certainly can't identify the who. This was a prosecution looking for a crime, working backwards. And all because they found blood on the bumper. Ms. Stermer, from pretty much the first night, within a couple hours, had a target on her back, a bullseye on her back. She's grieving the loss of her husband, and they make her take her clothes off to give it to them for evidence within 2 hours. Her husband's still there. Remember, you saw the pictures from Sergeant Leroy. He's there at 7 o'clock at night taking pictures of the body. She has to take her clothes off and switch clothes. She had a target on her back, a bullseye on her back, only because there was blood on the bumper, and as Sergeant Leroy said, time of day and 2 able-bodied people, and only one of them survived. And we'll talk about that is no kind of scientific evidence. We're going to talk about the scientific method in a bit. But I want to tell you about one thing. As you look and listen to Ms. Zuderveen, one of the things that she was talking about motive was the idea of they were in debt and she had a financial motive and she wanted to get money so they could clear the debts and whatever. Remember what Attorney Wilson said? Who interrogated Linda Stermer for 2 days. After his investigation, he's a 30-year lawyer, doing nothing but exams under oath, trying to detect fraud. What did he say? And your notes will say this. There was no financial motive. I looked. There was no financial motive. There was no romantic motive. So when you think about what's been said here, it's all about credibility. We lawyers, we hope we have credibility. We hope what I tell you is backed up by your notes and the evidence. But what Ms. Zuderveen told you about a financial motive was completely opposite from what the witness said. It certainly wasn't about romance and sex. Now let's talk a little bit about what Sergeant Leroy did, because we're going to talk about the fire investigation. Remember, we talked about the scientific method. You probably learned more about the scientific method if you're not into science than you ever wanted to. I used to be an engineer, and sometimes it makes my eyes glass. You have to collect the data. Most important step. This is always for these fire guys, figure out the ordinance cause. So it really starts with step one here. Collect the data, all the available data that you can that might be relevant to the task. Even Sergeant Leroy said that. All the available data. Remember, witness statements, building records, we'll talk about those. Physical inspection, excavation. Collecting data includes excavation of the property. That's where the gold is. That's where the evidence is. That's where you find the burn patterns and the objects that show you where the fire started and what could have caused the fire. Sergeant Leroy, under oath, and he admitted this, remember this? If you don't collect the data, you can't analyze it. You have nothing to analyze, which means you can't develop a hypothesis, which means you can't test anything because you don't have that, and you can't select a final hypothesis. If you don't do every single step, what do you tell you? You have an unreliable methodology. If you have an unreliable methodology, what do you tell you? You have an unreliable opinion. It can't be relied upon. It can't be trusted. The very definition of doubt. Garbage in equals garbage out. So we're going to talk about all the various things he did in order to comply with the scientific method, like he said he did, or this guidebook, which every single fire investigator trains to, tests to, and teaches to, NFPA 921. There were some questions about, this is the 2024 version. It's been going on every 3 years since 1992. But the main thrust is you have to comply with the scientific method. The scientific method has been around in sciences for decades. And so the fact that this was 2007, we're in trial in 2025. The 2024 version is what is in effect, what you have to comply with. And you might say, well, why are you holding that in 2024 when it happened in 2007? Because you have to be open to change your opinion based on new developments. And in this case, there are no new developments. It's the scientific method. Collect the data, follow the steps. That's fundamental. It was fundamental in 2007, it was fundamental in 1992, and has been fundamental for decades before that, the scientific method. So let's look at what Sergeant Leroy did. Sergeant Leroy got to the scene on the 8th, and then under oath, he told you, he went through the building, and he cleared with his friend Greg Stormzan, who you heard from yesterday, an area 20 feet by 20 feet by 2 feet, 800 cubic feet of debris. And what does that debris look like? This is Sergeant Leroy's picture of his area of origin. Oops. No. There we go. What did Mr. Leroy's area of origin look like when he was there? You see this? Right here? That's the first floor fireplace that we've been talking about. Here is a chimney chase that we were talking about. We'll talk about more about that. But here is the 2 feet of debris in this 20 by 20 living room that extends from the fireplace all the way to the bay windows. And what was his testimony under oath to you? Greg Stormzan and I cleared the entire living room and deposited it outside. And he said my pile was 4 feet by 8 feet by 7 feet high, as tall as shack. When you do the math, that's nowhere near an 20 by 20 by 2 cubic feet. That's about 28% of it. I had a calculator. And what did it look like when the next person came? The next person who came was Mr. McHugh. You remember that? And he took a picture of the back. He was there on the 10th. 2 days after Sergeant Leroy, on the 10th, and he testified, I think it was yesterday, maybe the day before, and all he saw was this. And then, Mr. Shinsky came, and Mr. Shinsky came a couple days later on the 11th, and his picture was better. But I ask you, where is this 4 foot by 8 foot by 7 foot high pile that Mr. Leroy said he excavated? Somebody steal it? He actually almost said, I don't know, or maybe. Here's the thing. Remember Mr. Shinsky? He said, I had to come back on the 15th with an excavator because it was too dangerous. So if it's too dangerous for a veteran like Mr. Shinsky, who, by the way, trained Mr. Leroy, then you know Mr. Leroy wasn't doing any excavation of the whole living room floor, and there was no clear 20 foot by 20 foot area. Shinsky's picture, after they came back with an excavator, you remember, here's the fireplace area, and there's the living room, goes out to what would have been the bay windows. Look at all that rubble, look at all that debris. I could basically, and by the way, Mr. Shinsky testified that he did the excavation. How do I know what he exactly said? Because I have his transcript, and we have his words. And his words were, in reference to the structural damage, you would then have to contract with someone else to come out and do the excavation of the house. Correct? No, I conducted that. You did the excavation yourself? Yes. Physically, hand by hand? Physically, hand by hand. And hired an excavator so we could remove the areas of the house that were hanging over the burned out section of the rear of the home so that it was safe to get in and actually do that. And then he continued, how many days did it take you to perform the excavation of the property? He said, I believe I was there for 2 days. You remember when Mr. Leroy first told you that he looked for his pictures of the excavation, and he couldn't find them. And then this half-truth, sometimes you just got to keep asking questions, and then you get to the truth. And then he says, I didn't take any, and I didn't make any reports. His testimony is directly contrasted by Mr. Shinsky's. And what was his excuse? It was a long day. I was tired, and I forgot. You remember I asked him, would you take that answer from some of your training? What was his answer? Yes. Well, it depends on the fire. This is a death case. It doesn't get more serious. Like Mr. Stormzan said, you have to bring your A game. Leroy, I can say it in lawyer terms, his story was demonstrably false. But if we want to just be real, he lied to you. And if he lied to you, you can't trust his opinions. Because if you can't trust the messenger, you can't trust the message. So when you go back and you analyze Mr. Leroy's work in this case, think about that. He lied about the very thing he needed to do, step one, collecting the data, so he could get to the conclusion, so he could develop the hypotheses, so he could try to figure out what went wrong and caused this fire. And you know what he said about that? He said, I didn't take any evidence because it had no evidentiary value. You see, there's that half-truth again that Ms. Zuberman's been talking about. You're right, you didn't take any evidence because you didn't look to find any evidence. When you analyze what he's doing, look at it in terms of his credibility and the high burden of proof. If you have any reasonable doubt about any of his opinions, especially when he lied to you, that's all you need. And when you have one reasonable doubt, ladies and gentlemen, about any issue, your job is done. Your job is done once you find one reasonable doubt. There's only two questions, really. You're going to hear, I'll tell you about the verdict form and first degree felony murder, first degree murder, second degree murder. It's all about, did you set fire and was it intentional? That's it. And you remember, well, we'll talk about it in a little bit, but as I said, one of the jurors was talking, we were talking about half-truths. When my kids, I think they're lying to me, I just keep pressing, and then I get the answer. We kept pressing, Leroy, and then we got the answer. So I want to look at these experts in this case, because this is very important. I brought to you Bob Trenkle. Bob Trenkle is almost a 60-year veteran. Got born, raised in Detroit, cut his teeth in Detroit, literally the murder arson capital of the world back then. He has trained people, taught people, tested, been on committees, and what did he tell you? He spent 2,000 hours in this case, 2,000, over about 10 years. And when I asked him, how much you charge? Like $200 an hour? And then Mr. Blair came up, he couldn't wait to do the math. And he said, I'm not charging anything in this case. I think there was a question. You're not charging anything, this is America after all. You must have a personal relationship with family, with Linda Stermer. There is no relationship. He spent 2,000 hours in this case. He knows every piece of the evidence, he knows everything that Leroy did and Shinsky did. Leroy spent less than 6 hours on the scene and developed his report. You know, he spent more time testifying, defending his opinions than he spent on the scene getting his opinions. And when you think about this, these are real questions that need to be asked when you go back to the jury, these kind of devil's advocate, cynical questions. Mr. Shinsky is a veteran, way more experienced than Mr. Leroy, taught Mr. Leroy. Mr. Shinsky was actually at the house, as you saw, same time Leroy was, same week, did the excavation, did an investigation. Why didn't they hire him? Why didn't they hire Mr. Shinsky to come in and tell us how good Leroy's opinion was and his methods? Maybe because Shinsky said, I did the excavation, and he would have known that Leroy lied. And the other thing is, Mr. Shinsky was asked to read this interview. Remember, read nothing but a transcript, bored the heck out of all of us. He's a fire origin and cause guy. He determined the origin and cause. Why didn't they hire him and ask him his opinions? Maybe because he disagreed with Mr. Leroy. And if you think there's any chance that's supported by reason and common sense that Shinsky disagreed with Leroy, that's an intentional fire, and maybe he determined based on all the damage that you can't just get every scene. It's undetermined, like Mr. Trinkle. That's why they didn't retain him. That's why they didn't hire the second most experienced guy who you saw in this case. And you know what? Greg Stormzan was with him. Remember, he was a partner on that excavation. Stormzan said, well, you got to document so people can understand what you did. And it'd be the guy who was supposed to, I was just assisting because it's not my jurisdiction. He's the one who's supposed to take photographs. He's the one who's supposed to report. He didn't. You can't just omit this stuff. And when you think about this poor excuse of I was tired and I forgot, did you forget to write a report? Would you forget you were tired when you were writing a report and left out the excavation? Or maybe you didn't do it. Maybe you didn't do what you said you did under oath to us. If there's any reasonable doubt about Leroy's methods, how he failed the scientific method, anything that's supported by reason and common sense, no matter how small, that's reasonable doubt. And when you get one reasonable doubt, you're done. Not guilty. By the way, Mr. Leroy really kind of has an inherent conflict of interest when you think about it. He's up here defending his own work, and nobody's defending him. So like I said, he spent more time in the last 18 years defending what he didn't do than he spent getting the evidence. Follow the science, ladies and gentlemen. When you look at what was done here by Leroy, follow the science, what he collected, what he analyzed in 2007, and not what they're trying to suggest, well, so-and-so backed you up on this in 2024. That's not when you do investigation and the lack of excavation. 2007 is when you hold him to the evidence that he collected and his analysis. Follow the science, follow the objective evidence. We brought you objective evidence. And by the way, defendant has no burden of proof. We don't have to show you anything. We didn't even have to call a witness, but we did. Called Mr. Trenkle. We called Dr. Z, who said this is a 5-mile-an-hour impact. We'll talk about that as it gets to whether Linda Stermer intended to do anything. But let's talk about the reasonable doubt in this case, starting with, as I said, Mr. Leroy's conclusions. And so I didn't want to write it on the board. My handwriting kind of sucks. Here, Leroy's opinion. Opinions are not reliable. Garbage in equals garbage out. And there was a whole lot of garbage in what he didn't do. You can't trust his opinions because you can't trust his methods because he didn't do it. He didn't comply with 921. He didn't comply with the scientific method. Did Leroy rule out an alternate area of origin? You remember, Mr. Leroy agreed with me, his living room here is about the size of this courtroom, all the way to the bench. Sometimes, as you saw in NFPA 921, it says, sometimes the damage is just too much and the area is too big, and you can't make conclusions. You heard Mr. Trinkle. Ideally, you're trying to get to a point of origin. It was the back of the toaster. It was the electrical outlet. The bigger you get, the worse your reliability of your opinions are going to be, because they're just too much. And by the way, when you look at this and you're considering reasonable doubt, think about this. I stood here. Did the fire start here? Don't know. Did the fire start there? Don't know. Did the fire start there? Don't know. He can't tell you the where. If he can't tell you the where, you can forget about it. Because remember what NFPA 921 says? If you're not in the right area of origin, you can't find the cause. Because the cause is going to be in the area of origin. But if you don't look, and if you don't excavate, you will never find it. So then we talked about alternate areas of origin. Remember the chimney chase? And Mr. Trinkle said, the chimney chase, you heard from Cassandra Grigg, one of the witnesses yesterday. She talked about, first of all, everybody talked about this house was unfinished. The whole living room is OSB pressboard, subfloor with a couple throw rugs. And the chimney, the surrounding area, was pressboard. You didn't hear them bring anybody to say it wasn't. They could have asked the two boys. They had them up there today. What about the chimney? They didn't ask that question. There's a reason they didn't ask that question. They didn't want to hear it out of their own witness's mouth. Could the chimney chase reasonably be a possible area of origin? Well, Mr. Trinkle told you it's consistent with the witness reports of a fire from the back rear of the place, flames shooting out of the roof. Chimney chase, that chimney chase is 2+ stories high, and if you have a problem in the chimney from the flue, which you saw that rubble you didn't even analyze, then you can have rubble pouring down, and by the laws of physics, things don't drop straight down. They go in arcs. They could fall out and down, in an arc. And when you have a wall collapsing, that would be consistent with getting Todd in the living room. That would be consistent with his burns on his hands. And that would be consistent with a pretty sudden fire and him screaming. So we don't have to prove that it's the chimney chase. We're not here to prove that the chimney chase is where the fire started. He can't rule out the chimney chase could logically possibly be the area of origin because he didn't do the work. And if you can't rule it out, that's reasonable doubt. Let's look at the next one. Gasoline was on sweatpants, not related to the fire. Can he rule out that maybe the gasoline he found on the sweatpants had nothing to do with this fire? Well, remember his testimony? At least he was candid with me, because I had his old testimony from 4 years ago. He has no opinion on whether the gas on the sweatpants had anything to do with this fire. He said, I don't know how it got there. I don't know where Todd was when it got there. I don't know when it got there. I don't know when the last time the pants were washed. I don't know any of it. So finally he was candid enough, because I had him trapped, to say, I don't know. I have no opinion. Well, that's the whole linchpin of his whole gasoline in the house, because he admitted there's no gasoline in the living room. None was found. None. If he can't rule out that the gasoline has nothing to do with this fire, then you have to return a not guilty verdict, because that is reasonable doubt. That's the whole basis of his opinion. I'm sure you folks have notes on that. Now, this is important. The other thing that can cause reasonable doubt is, do you remember when I was asking him about his opinion, he relied on Linda Stermer and her testimony about being in the laundry room and running upstairs when Todd screamed. He was upstairs, she's downstairs. You remember, you heard a lot of talk today about all the inconsistent stories. What you've heard from every single witness who talked to Linda Stermer is that she was downstairs and Todd was upstairs when she heard this horrible scream and he was on fire. And she ran upstairs and then her world turned upside down. So, my evil plan. Todd was upstairs. Linda, forgive me, that's my mom used to draw her when I was a kid, was downstairs. She was downstairs and had to run upstairs. Even Sergeant Leroy agrees with the obvious, you can't be two places at the same time. That means when he caught on fire, she wasn't there. She wasn't with him. And the interesting thing is, oh, wait. Interesting thing is, when Mr. Blair apparently realized this is checkmate on reasonable doubt and where the fire started and the cause of the fire, he started asking, well, isn't it possible that maybe she could have poured gasoline on him and ran down the stairs and there was all these fumes and she didn't get any gas on her after doing that? Testing to 0.0005, not a drop, not a speck on that high-tech machine? No, there's no such thing as possibility. You heard every legitimate expert say, we don't guess, because guesswork masquerading as expert opinion testimony is junk science, and it's frankly unethical. We don't do that. So this idea of they'd like to show possibilities, you don't deal in possibilities. You are the judges of the evidence. But the evidence from their expert, I'm not an expert of fire science. You're not presumably an expert of fire science. You have to rely on the evidence that you heard from the witness chair. And the evidence from Leroy and Mr. Trankel was she was downstairs, he was upstairs. She wasn't with him. If there's any reasonable doubt that she had nothing to do with the fire, not guilty is your job. What's another reasonable doubt? No evidence of an ignition source. Let's talk about that for a little bit. Because you don't collect any evidence, he couldn't find any evidence of an ignition source. Remember we talked about NFPA 921 and causal factors. Causal factors, if you'll recall, you look at your notes, you have to have an ignition source, and you have to have a first fuel. Ignition source, what's the thing that made something catch fire? Sure, first fuel. What's the first thing that caught fire? And most importantly, how did 1 and 2 come together? He didn't have any evidence of an ignition source, so he supplied one and said it's an open flame. Could be from the fireplace, could be from candles, don't know. Well, he didn't rule those out either. And then he said gasoline, but see, this is circular, because he said gasoline on the sweatpants, which he's admitted he didn't know how long it had been there, means there's gasoline in the house. That's completely illogical. He didn't have a first fuel. And he certainly couldn't put 1 and 2 together to tell anybody what caused the fire. How did the first fuel, even if it was open flame, 2, gasoline, how did it come together? What's the first thing that happened? Doesn't know. What's the second thing? Because you have to, as an expert, you have to do this. You have to say, this is the first thing that caught fire, and based on our training and experience, we know this, the fire propagated this way. This caught fire, then it caught that fire, and it caught that fire, and it caught that fire. You tell how the fire started and how the fire progressed. He couldn't do that because he didn't do step 1 of the scientific method. He didn't collect the data. Garbage in equals garbage out. And when there's garbage for the out because of garbage from the in, that's reasonable doubt. Doubt calls into question confidence in his opinion based on reason and common sense. Reason and common sense tells us you can't be where the fire started if you're downstairs. He couldn't give us the how. Frankly, he couldn't even give us the where because he doesn't know within this huge area of origin where the fire started. Number 9. Since he couldn't tell us the cause, he certainly can't tell us the classification. Accidental fires, natural fires, lightning strikes, undetermined, and incendiary. Incendiary is the only classification that supports a crime. And if you don't have a cause, you can't have a classification. If you don't have a cause, the only intellectually honest thing you can do with integrity and honesty is say, it's undetermined. And there's no shame in that. Because sometimes fires are just too total. The damage is just too much. Did he rule out an electrical or mechanical cause of the fire? Well, he's admitted he's not an electrical expert, and he's admitted under oath that he didn't collect anything. So how could he rule something out that he didn't collect? And what does he do? He explains that, well, electrical fires in walls, they start small and slow, and so this is why this whole able-bodied thing comes into play. And an able-bodied person, if it's electrical, could figure that out and escape. Electrical fires in walls can explode all the time. It happens all the time. Did he exclude and rule out a mechanical cause? The flue. You saw the damage to all the flue pipes. That's why we bring in people, and they look at it, and they try to see what could have been a failure of the flue, and that's how things started in the chimney chase. He's not an expert, he said that. He didn't collect the data. You saw how Shinsky laid out the stuff like you're supposed to do. What did Leroy do when he was tired and it was a long day? He threw the stuff in a pile in the back of the house. And forget about 123, We'll get it. You remember Shinsky's photo. He just piled it. There's no analysis, there's no thorough investigation, there's no thorough, rigorous testing, which is what NFPA and a scientific method say you have to do. He just threw it out so he could go home because he was tired. And remember I asked, why didn't you just come back the next day? You didn't have an answer for that. Wouldn't you have told your young associate? Nothing wrong with going back, why didn't you go back? And why didn't you write a report? And why didn't you do what you were required to do in this death case? Then he didn't rule out contamination of the sweatpants. Remember, he found 3 hours later, Todd Stermer, and he smelled gasoline. We'll talk about that in just a second. He smelled fuel. I shouldn't say gasoline. He said, at least he's honest. Fuel is fuel when you're smelling it. I don't have a super nose. So he smelled fuel, and that's why he took sweatpants. But remember, he's there 3 hours later, and this is the final point of arrest for Todd Stermer after he's been taken in the boat to here. So if you find him here, you have to analyze could there have been a transfer to the boat, or you remember, Bikini put clothes on him, a bunch of clothes, and they found that here, right? Could there have been contamination from there? It's not whether there was, it's whether he can rule out the logical possibility that there was. And how do you do that? You use the scientific method like all scientists do, like all professionals do, and you collect data, starting with the boat, working backwards. I said, did you use a rag, anything? No. Did you talk to anybody? No. Talk to the family? No. That's all data? No. I don't even think he knew there was a boat involved. So he couldn't collect the data, so he couldn't do the rest of the steps, so he couldn't comply with the scientific method, which means that his methodology is garbage, so any opinion that says that didn't matter, that's garbage too. If he didn't rule it out, that's reasonable doubt. These are 11 different things that I've come to. When you go back, you were taking a lot of notes, you might find more. When you think about all the evidence, you might think, let's look at that. Did you consider that? Maybe that's reasonable doubt. You might find more than I did. But you don't take possibilities. Pros don't take possibilities. So when Ms. Zutterbein, like Mr. Blair, says, was it possible that this happened? That's not evidence. That's speculation. That's guesswork. Experts don't do that, and you can't accept that as valid evidence. Not only was there Mr. Leroy's shortcomings, but you remember a lot of the police witnesses who testified. Oh, let me segue here. Let me just back up just a little bit. Do you remember, all of a sudden, remember this fire chief who had been retired for a lot of years, and he comes in, he said, I've done hundreds of fires. And all of a sudden he remembers, yeah, I smelled fuel too when I was there. He didn't write any report 18 years ago. He's never said that ever in any document. But he admitted, I met with the prosecutor, and we talked about what my testimony was going to be. So it's kind of weird that all of a sudden people 18 years later are saying things that they never said and never wrote. So when you consider credibility and the credibility of the witnesses as you're analyzing whether there's reasonable doubt, think about that. Every law enforcement person who came in and said that they smelled fuel at the scene on Todd Stermer never said it before and met with prosecutor. Fair. One more thing I did forget. There was talk about the construction of the house. And this is real important because as you're analyzing how could the fire started, could it have been an accident? Remember Brad Stermer, the older brother? He said, I was in college, and remember we had that yellow house that was my dad's, and Todd was the main guy working on it, and he said, I'm a handyman, and I'm good at it too. But we didn't have any money. I think the phrase was, we're scraping nickels together to get it fixed. And he admitted, we didn't use the best equipment, the best components that were doing the house. And 5 months after they finished, with Todd at the helm, being unlicensed, that place burned. And he said, that was an accidental fire. Well, that can happen when you don't have licensed contractors. And good as you may be as an amateur, you're not a licensed electrician, you're not a licensed mechanical person, HVAC, nothing. That can happen. And you can't rule out that happened in this case. And we know why? Because it took, what, 6 years for this house to be built? You're scraping nickels if it takes 6 years to build a house. You're doing what you can when you can afford it. You heard, and maybe it's because of the horses, but you heard they were having money troubles. That's why they didn't build it. That's why they were scraping nickels. And he was at the helm. And you heard, not only did you hear from all the people who've been in the house about all the exposed wood, which is why it would have gone up so fast because it was a tinderbox. Then you heard the last witness we had, Rich McGrew, who said if you don't get a final electrical, a final mechanical, and we don't certify it as good for final occupancy, it is a unsafe house. Why unsafe? Because you can have fires. So you're not here to supply evidence. You're here to address the evidence that was given to you. And in that sense, you can't rule out that because of poor construction, this could have been an accidental fire. And the fact is, because it's a tinderbox, that also explains the speed of the fire. But at least Leroy was candid enough when I questioned him and caught him in some demonstrable untruths that he said, yeah, I didn't know how the house was built. I didn't know that it had OSB flooring. I didn't know that there was no final certificate. I didn't know that it didn't have final inspections. That's all data that you can collect that's available. You know who collected it? Len McHugh, the property adjuster, who, by the way, Linda Stermer asked him, why are you here? Because we don't have insurance. We'll get to that in a second. But he's the one who collected the available data, he said, from the building department, which is what Leroy could have done, but chose not to. Garbage in equals garbage out, makes it unreliable, it can't be trusted, and if it can't be trusted, that's reasonable doubt. Now, let's talk about the police work in this case. In this rush to judgment, where they first, I will say, they got misled by Leroy, who called it an incendiary fire. So in their terms, in police terms, that's an arson. And we have a guy who's dead and we have blood on the bumper. Now, their rush to judgment resulted in all kinds of sloppy work. First of all, this missing video that we're talking about, which would help anybody, including a defendant who's under arrest, determine how the fires were spreading, that's gone. You heard Cynthia DeLoach, the gas station attendant? I asked Maciaski, you've got the cash register tape and the video from the place in February of 07, a few weeks after. It's stuck in your drawer for 2.5 years. And is that proper protocol for property preservation? I'm not sure what the protocol was back then. You're a veteran cop. Your command staff. You don't know this? Or is this just another half-truth? Mislabeled evidence. Remember that coat that was in the silver can that turned out to be Mike Matheny's coat, that red checkered one? That was labeled Todd Stermer, which helped Leroy determine, well, everything that's tested positive for gasoline is Todd Stermer's. Therefore, couldn't be any contamination. He didn't realize until later, oh, that's Matheny's coat. And he didn't rule out the contamination from Matheny's coat or the boat. We didn't rule that out. That's reasonable doubt. Witnesses weren't interviewed for 2.5 years. Cynthia DeLoach didn't get interviewed until 2.5 years later, June of 2009. And remember the testimony from her? I knew Deputy so-and-so, and he'd come in all the time. Have you talked to the folks? Have you talked to my bosses, whoever's running the investigation? No, nobody's going to talk to me. Remember Maciaski, who said, I got too busy. I forgot. Everybody seems to forget here. He got too busy. He didn't go see her for 2.5 years. When you look at it with a bit of a jaundiced eye, this other detective, if he's going to Cynthia DeLoach, what you say, every month, every 2 months or so, have you talked to us? Have you talked to our guy? Have you talked to our guy? You think he's not going back to the department? Why don't you talk to this woman? She's got evidence. He didn't do it. And by that time, she forgets, because you heard her testify, I don't know if Linda Stermer was pouring gas. I didn't know, she said, I think she was, but I didn't see a container. Now, think about this, because I want to talk about this red gas can that was found in the front yard. And they're trying to relate it, one to the fire and all the way back to Cynthia DeLoach. This gas can that was found by Leroy, you can see, has a broken spout. He didn't know how long it had been there. This gas can, they tried to relate to and make this big conspiracy by Linda Stermer. She went and bought gas in the morning, and she put gas in the truck. Linda Stermer is all about 5'6". Chevy Blazer, remember the talk was the hatchback. 5'6" woman doing this into a gas can, and you didn't spill a drop of gas. You didn't spill any gas. You didn't get out of your clothes. You didn't get out of your hand. How do you pump $11 of gas, roughly 4.5 gallons, into a 1 gallon tank? You don't, because there was never any gas being pumped into a gas tank. And how do we know that? Because Trevor was honest enough when he testified to say, remember when we went to the mall in the Blazer? I didn't smell any foul smell. You know gas smells, right, Trevor? Yeah, I know it's snowflake. You didn't smell anything, did you? No. Anybody, believe me, when it's time to use a snowblower and I got to go to the gas station for my gas tank, I put it in the truck with the SUV, it smells. And how many gallons spilled drop? But anybody who spilled gas on clothes or their hands, it reeks for a while. So when you think about credibility and what is trying to be portrayed as this grand scheme, reasonable doubt. Was this even connected? No. The most telling evidence is their expert, Leroy, said, I have no idea. It has anything to do with it. So what you're being told by the prosecutor is some theory based on no evidence. Trying to connect dots. But it's a bridge too far, a road too long. You can't connect dots because all you're doing is guessing. And you as a jury have to evaluate the evidence, not the talk of me, not the talk of Ms. Zuderveen. Judge will tell you that. What we say is not evidence. What they said is evidence. Leroy said, no idea. No idea. Now, we have all kinds of reasonable doubt, at least 11 things, just in terms of how the fire started or where the fire started. But now I want to talk about the second part of it, intent. Did Linda Stermer intend to set a fire? Let's look at the objective evidence. Then we're going to talk about all these 5 ways that Ms. Zuderveen said Linda Stermer tried to kill her husband that day. 5 different ways, and we'll analyze that against the objective evidence we have. First, the thought and the theory by the prosecutor is Ms. Stermer, struck Todd in the van, therefore she intended to kill him. Well, let's look at that through reason and common sense. And if you lack confidence by using your reason and common sense, that's reasonable doubt. You heard the 911 tape.
Oh my God, Take it to us, say what you don't want to see. We just want to know anybody inside the house. I'm not getting hurt now. Okay.
That, as you know, was Connie Calhoun, and you saw her stress level, the chaos she was going through. She wasn't in a fire. Her spouse wasn't on fire. Her house wasn't on fire. And you saw how she was. And by the way, every person who testified here from law enforcement or people like Connie Calhoun and Mike Matheny and Dr. Masali all testified she was hysterical. She was beside herself. Now, she would have to be the greatest actress in the history of Hollywood. Meryl Streep would have nothing on her. And by the way, remember the theory that Zuderveen just told you? She was driving down the driveway. She was escaping. Let's look at that. The reason and common sense. And see if we doubt that statement. Who is a mastermind who supposedly got gas in the morning in a gas can, the torture place, scooted the kids out, and then is escaping, as she said, and escaping with no shoes, and escaping with no coat in January, and is escaping with no cell phones in January, and is beside herself hysterical? All it takes is a little bit of doubt based on reason and common sense. And anybody who heard that 911 call cannot come to any conclusion other than she was shocked by the fire and she was in a state of panic. You heard Bob Trankel. Firefighters, police officers, military folks, they train so they can have muscle memory when the stuff hits the fan. She's a middle-aged woman who never engaged in any of that. And she acted like it, like she lost her mind because it's fight or flight. And she ran. She wasn't escaping. She was trying to get help. And it is pretty darn cynical to listen to that 911 call and to say she was trying to escape this mastermind was. Now, there were talk about valuables in the house. One of the things you look at is any cynical person like Wilson would be, is if you're going to torture your house, I want to make sure my pictures of my kids and all my valuable stuff and all my guns and everything else are out of there. Then I'll torture the house. Remember, Trevor's baseball cards that were so valuable to him were found in the basement in the rubble. And you heard from Tina, Benny, and she said, my husband and I, we had this handmade little sister, and we found a wedding ring. Linda's mom's wedding ring, valuables that were in the rubble, by using equipment that Scott Leroy should have been using, that he has, that they use. So this idea of you hide valuables, reason and common sense, and reason and common sense tells you if you have a financial motive, you kind of know you had insurance. Linda Q said, she asked me, why are you here? We don't have insurance, our insurance lapsed. This is the financial motive? This is the get rich quick scheme by this mastermind? There's no intent. There's reasonable doubt as to every bit of intent here. Oh, then let's talk about these 5 ways, the 5 best ways to kill your husband in the same day. First, she tried to drug him, then set a fire. Where'd that come from? Kate Fox with a coffee cup, remember? But Kate Fox told us, Linda Stermer said, I put the coffee cup and I didn't drug him because he was already on tranquilizers. Let's look at the objective evidence about that. Dr. Markey told us in no uncertain terms that there are no drugs in the system. And when we talk about who's being square with you and we want to have credibility, Dr. Markey said the remnants, the metabolites of hydrocodone were in the urine. That's not active. There is nothing but caffeine in the bloodstream, the active ingredients. And the metabolites that are in the urine, which last longer, were explained by the medical records that we just admitted today from the family physician, who prescribed Entex HC, a narcotic for ear infection that has hydrocodone. Dr. Markey admitted hydrocodone is consistent with taking this cold medicine that the doctor prescribed. So when we're talking about what the evidence represents, like I said, thank God what we say is not evidence. You can rely on your notes and you can rely on the transcripts. Well, you can't rely on it, I can. And also Ms. Stermer said that Dr. Markey had no opinion as to whether the skull injuries, the lacerations on the head, were related to the van versus something else, which you're suggesting is a frying pan. Dr. Markey said on page 18 in his testimony Those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it? Well, the injuries themselves, as I stated before, very well it could be to being struck and overrun and striking things on the undercarriage of the motor vehicle. That's his actual words, not what Kurt he said. And you can look at your notes, because these are the actual words under oath. And it's consistent with Dr. Zacheski, I just call him Dr. Z, who is a renowned biomechanics injury mechanism expert with decades of experience working with brain injuries, who told you all of the lacerations and these skull fractures. It sounds bad, skull fracture. A depressed skull fracture has been explained as you take your finger, there's some icing on a cake. It doesn't even hit the bottom of the bone. There's no linear skull fracture. There's no brain injury, as Ms. Zuderveen tried to suggest, Marky said. That's not on the autopsy. These are AIS-2 injuries, Dr. Z said. Moderate injuries. Not related. There's no evidence that it was related to a frying pan. So that's the first one. Drugs, set them on fire. Number two, crack them with a frying pan. Then set them on fire. Except that came from Dardita Gordon, who admitted to so much mental illness and on so many medications normally that she would have been, except she was in jail when she gave that statement. And she said, they don't give me my meds in jail, and I have memory problems. And guess what? She admitted that it was Detective Maciaski who suggested, could it be a frying pan? It was a jailhouse snitch. Yeah, I guess it could have. You look at all of this with a cynical eye, and when you're evaluating the witness's credibility, that's unreliable. That's not consistent with the physical evidence. We don't have to prove anything to you, but we bring you objective evidence, follow the science, follow the objective evidence, and you can't come to any other result other than there's reasonable doubt. And by the way, what devious mastermind who's going to torch the place and kill her husband spends the afternoon packing up Christmas decorations? What, an hour before I'm going to torch my place and kill my husband? None of this makes sense. Starting with all these witnesses who prepped with the prosecutor and all of a sudden change your testimony or hear new testimony. So frying pan is number two. Setting the fire by itself, well, we already talked about that. That's clearly reasonable doubt as to where the fire started. No doubt as to Linda Stermer didn't have anything to do with it. And you didn't hear a single word from Mr. Leroy or the prosecutor that gas on the sweatpants had anything to do with Linda Stermer. Because if they had that opinion, it would have been front and center. It would have been blown up on a wall 10 feet high. No opinion, your notes, you pull them all. Nobody will find a note that says that. The gas on his pants, which he claims is the whole key to the case, that it had anything to do with Linda Stermer. 4, run him over after you set the fire. Well, you heard testimony from Dr. Z that it's a 5-mile-an-hour impact. And those injuries, you didn't see anything where he was run over by a 4,500-pound vehicle, no broken legs, no broken bones, rib fractures consistent with CPR, no brain injury, no skull injury, no nothing other than icing on the cake and some lacerations consistent with being run over at a low speed, as Dr. Z said, with a high load. High load is just, it's a 4,500-pound van. And Dr. Z's testimony is undisputed. Because don't you think, with the resources that the government has, if they could find anybody, and I mean anybody, to counter Dr. Z or counter Dr. Markey, that they would have? But it's the same group that's letting Leroy defend himself. They won't even hire Shinsky, because Shinsky's not going to go their way. And finally, the fifth way she tried to kill him that day was to suffocate him. So here she is in this panic state of chaos, fight and flight, and out of her mind, and she's crying, she's yelling, Todd, Todd, stay with me. And what did they say? We think she was laying on top of him. She wasn't laying on top of him. She was trying to hold her husband and keep him alive. And if there's any little doubt that you have that's supported by reason and common sense, that doesn't require you to abandon reason, then that's reasonable doubt. And if there's reasonable doubt, you have to vote not guilty. There's no intent here. Clearly reasonable doubt as to the intent and lack thereof. I'm going to talk a little bit about the inconsistencies, and of course, there were a lot. But you know what they were? They were details after she got to the top of the stairs, when her world blew up. While she was downstairs and calm, everything consistent. I'm in the laundry room, and Todd is upstairs, and that was relied upon by Leroy in terms of finding the area of origin. It corroborated his physical findings. His physical findings corroborated her testimony. Nothing about these witnesses that they're bringing you is being corroborated. We talked about how Mr. Trinkle said how people train so they hope they can combat panic when the adrenaline is high in a stressful situation. And when you're in the jury room, I want you to think of this. A lot of people, Monday morning quarterback, and go, I wouldn't have done that. I would have jumped on my husband. I would have saved him. While you're having a cup of coffee in the jury room, or you're watching TV in 2020, I would have done this, I would have done that. You don't know what you would have done. What you would have done and what you could do in the situation are two vastly different things. So when you're thinking about what she was going through, you have to put it through the lens of this high burden, this presumption of innocence, and that none of us know, unless you've been in a fire and running out in your underwear, what people go through. I'll talk a
And we are gonna leave him there. We are not gonna talk about anything else, dude. We are over with you. I am sorry, but I am not sorry. Because it is 5 minutes to the hour to when Lori Vallow starts, so we just gonna start that back up. They're still not live, they're still about 5 minutes, but I still Yeah, I can't hear it anymore. I can't. I'm sorry, guys. I am like here falling asleep. I'm getting a little bit cold, so I might have to go grab a jumper or a jacket or something. I don't know where I have one. I think I may have to go to the bedroom and grab one. But when Lori starts, and I need to turn off that screen behind me because it's starting to glare as well. So I need to get that done too. Um, so oh yeah, don't worry. It's already here. We're ready. I'm ready for it. So definitely we are gonna be there. We're not gonna lose anything from Lori. I don't think they are gonna deliberate nothing so far because the woman prosecutor is still talking and it's literally 4 minutes to 5 p.m. and I don't think this judge is gonna go further than that. If they are, don't worry, we can be on verdict watch while we're doing Lori, like we were planning anyway. But I don't think. I think they are gonna come back tomorrow for verdict watch and for that. So what we're gonna do is um suffer a little bit more, and we're gonna finish the closings tomorrow and the rebuttal tomorrow while on verdict watch, and then hopefully by the time we finish that they will have a verdict. That would be way too good and that would be perfect. So that would be way too perfect. Probably definitely is not gonna work out like that, but yeah. So um ready, Freddy. Yes, we are ready for this. I am ready for it. I am getting a little bit tired already, but it's okay. We can do this. But like I was just thinking, right? And you guys can correct me if I am wrong. Um we did not had the morning break, did we? Because I don't remember having a morning break. Did we had a morning break? I honestly don't remember. My memory today, my head is just like all over the place, and I don't remember. I remember we had Adam Cox and we had Serena Sharp, which is still on the stand. We are gonna come back, and I think it's gonna be still a direct examination or cross or something on one or the other. And then yeah, I'm a bit confused. I don't remember. I honestly don't remember, which is weird. I mean, not having a morning break. I mean, I'm not complaining, right? Um um you know, it's a bit unusual, yeah. Weird. But I found interesting, and I want to see if Lori does the same. Yeah, it was short, wasn't it? Was that 1 hour and a half, the morning part? Oh, good morning, Ay Vamos. Buenos dias, my friend. How are you? I haven't seen you. I hope you're okay. Um, so, that is weird. That was good. I mean, I'm not complaining because we were engaged watching it and learning. Yeah, no morning breaks. Okay, that's what I thought. So, howdy. Hello, Ay. Buenos dias, friend. Well, buenas tardes. Yeah, that's what I thought. But one thing that I was saying before we do go back to court, right? I was just thinking that Laurie asks something new in at the end of the Adam Cox testimony, right? And I'm gonna see if she does the same in the Serena Cross examination. She asked about did she witnessed her like conspiring to commit the unaliving or anything. I don't remember exactly how. Oh, thank you. Hang on, I'm actually gonna check that. 1 second. Yeah, no, it is normal. Thank you, Denise. It's fine. You could said on stream. It's fine. Thank you. I appreciate you so much for helping me out. I really appreciate it. So what I was just gonna say is, yeah, ask if they conspire with Alex to unalive Charles. That I like that fact. You know, that, well, I don't like the fact that it's not her, but her legal advice that is doing that. But it is a good question. I'm not gonna lie, it's a good question. So probably no AM break due to the starting late next week, since they will be starting an hour earlier. Iowa, that could be, but they have been having morning breaks, I think. But that could be, yeah. I mean, starting an hour earlier, that would mean that they probably would finish earlier, or they would go. I don't know if they would finish earlier, but the trial would finish earlier because it would be more trial done, which would be good because we are going on at a good pace. I mean, we are on the 9th witness for the prosecution. I know prosecution has 21 witnesses on their list. I don't know how many. I mean, I think Lori has, hang on, I have the list. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 witnesses on her list. So yeah,
Defense ready?
I think that's for Lori outside. So
Paralegal coming?
My investigator should be here, but I don't know if he's
oh,
ready.
I did not know that. That is interesting
All
to
right, let's
know.
come to
Thank
jury.
you for that. Yeah, that is actually quite interesting. Thank you. So, yeah. Well, he has to. I mean, he has to do that because otherwise she's just gonna take over the court, and she was already doing it with the smart snark comments and all of it. So he has to do it because otherwise she will just run wild. Yeah. So can someone just put on the chat the name of the witness is Serena Sharp, and say on the stand, please. Thank you. Sorry, because I'm just checking something on the stream of the Linda Stermer case. I need to keep an eye out for that as well. They are on a sidebar. Imagine they are on a sidebar two there, but because I think they are saying they are going to come back tomorrow for verdict watch, or maybe see if the jury wants to stay tonight actually. So I'm just trying to see.
Reading to you final instructions, but I'm looking at all of you, and you look
Sorry.
exhausted.
Yeah, okay. Judge in the Linda Stermer
The
case
state can
is
proceed
sending
with,
jury to home. She will read jury instructions.
So we were talking before lunch, and you have told us that you sort of spent 2 weekends getting to know Lori Vallow, correct?
Yes,
That was the November of 2018 visit,
with a lot of other people there, correct? Yeah,
and then the March of 2019 visit.
yes, the girls' weekend,
And that was a much smaller group of people.
correct.
And I think you had said that as Lori started expressing some of these beliefs that went against the LDS religion, that you started sort of questioning her about this.
Correct.
After that, did you feel like she started pulling away or limiting her contact with you?
Yes,
You told us that you had moved to Arizona in end of July or August-ish of 2019, correct?
yes,
Did you ever see Lori again after you moved to Arizona?
twice more.
Can you talk to us the first time that you saw her?
The first time I saw her, Zulema organized a girls' lunch to welcome me, she said. And so Lori was there. She came with Alex, her brother, and basically I said hi. And not much more than that. She sat on the other side of the restaurant, opposite of me. So, and not much contact there, but
Okay. And then what was the other contact you had with her?
I can't remember how it was organized. Perhaps at that lunch, Lori invited the women over to her house for to just talk. And she had just lost her husband. And I don't know if I was included by accident or how that happened. I don't remember exactly, but I did go over to her house that night because here's somebody that I knew, and she had just lost her husband, which that's a big deal. And I wanted to find out how she was doing and what was going on.
Did you know anything at that time about the loss of her husband? Like what had happened?
I had heard vague things, but I had been across the country, so I didn't know any particulars.
Do you recall who was at the house that night?
Multiple women, but I actually don't remember who was there. I think Melanie Gibb was there, and then a few other ladies, but I actually don't remember who.
And do you recall, was still that same time frame of like either the end of July or the beginning of August?
Yes.
Can you describe for us Lori's demeanor at this meeting, this gathering at her house?
I would assume, like in my estimation, it was more like stoic. I didn't see any like mourning or crying.
After that contact with Lori, did you ever see her again?
No,
Did you know that she had moved out of state?
no, not till long after she already had.
Did you know that she had married Chad Daybell?
Nope.
So basically, after paying your condolences, that was sort of the end of your contact friendship with Lori Vallow?
Yes, I think there might have been a few texts after that just to check up on her and see how she was doing. She had just lost her husband again, so, and I think she was trying to figure out how to move forward, and I was concerned. So, but nothing of substance.
Was your interactions with her via text very limited?
Yes.
No other questions, Your Honor.
Cross-examination.
Ms. Sharp, did you take an oath when you came into this courtroom today?
Yes, I did.
Did you raise your hand?
Yes, I did.
Did you swear to tell the truth?
Yes, I did.
The whole truth?
Yes.
Nothing but the truth?
Yes.
So help you who?
God.
So can we agree that this court acknowledges that your testimony here today will be accountable to God?
Your Honor, I'm going to object to the relevance of this.
Sustained.
Your Honor, they brought up the religion.
Ask for a response. It's sustained. Ask the next question.
Do you believe that your testimony here will be accountable to God?
Yes.
Okay. Ms. Sharp, how many times did we meet in person?
4.
How many one-on-one conversations during those meetings do you think that we actually had? Just you and me, nobody else around, just you and me.
Maybe 2.
2 conversations in our whole lives,
Maybe
just me
3.
and you.
You said during those meetings.
During the 4 times that we saw each other in person, how many times did you and I have a one-on-one conversation where other people were not in the conversation? Just me and you.
I can remember 3.
Okay? And how many times did we communicate on the phone?
Do you want me to estimate? I don't remember how many times.
Sure, just an estimate.
I'm not sure how to estimate that. Multiple times?
Like more than 10 or less than 10?
Probably more than 10.
More than 20?
I don't remember.
Okay. And text messages, the same. How many times do you think that we conversed via text?
I don't know. I'm not sure how to answer that again.
Okay, so would it...
Multiple times.
Okay. So would it be fair to say that some of the things that you remember are from other people and not actually from me to you directly?
Perhaps.
Okay. So in the instance when you said that I mentioned to you something about zombies, I would like to know what I said to you exactly verbatim about zombies.
Well, I remember we talked about zombies in 2019 for the girls' weekend. You had
Okay.
mentioned zombies.
I mentioned zombies at that weekend out of my mouth and not someone else, but me.
Object to argumentative.
Overruled, you can ask, why don't you rephrase that question?
Okay. So you're saying under oath that I said the word zombies at that meeting, or I'll go with that.
To the best of my recollection, it was that weekend during the girls' weekend, 2019.
And
Again, that was 6 years ago, so like verbatim, I don't remember verbatim, but I think it was that weekend.
So it could have been that someone else was talking to you about zombies, but I was actually there also. Is that correct?
I'm going to object that the witness has answered that question and said it was her.
Overruled, she can answer.
Would you mind restating, please?
Is it possible that someone else said the word zombie and not me at that meeting when we were all there with the girls?
It's possible, but I don't think it was. I think
Okay,
it
then
was
what
you.
did I say exactly about zombies? I want to know the sentence I said to you about zombies.
Hold on,
Again, just
ask questions, okay?
I
make
object to
statements.
asked and answered.
So rephrase your question.
What sentence did I say to you with the word zombie in it?
And I'm going to object to asked and answered.
Technically, it has been asked and answered, but go ahead and answer.
Again, I don't remember verbatim. That was, 6 years ago?
So it could be possible that it really never came out of my mouth. Is that true?
Okay, I'm going to object again to asked and answered now a third time.
Sustained.
Ms. Sharp, who are the three Nephites in the Book of Mormon?
The 3 Nephites? I'm sorry, I don't understand the question.
In 3 Nephi 28, the three Nephites, do you know who they are?
Off the top of my head, no.
You do not know who they are.
No, not off the top of my head.
Okay. In the Bible, do you know of John the Revelator?
Yes?
Do you know of John the Revelator being translated?
I don't remember that, but
You don't remember that? What about in the Old Testament, Elijah? Was he translated?
Your Honor, I'm going to object to relevance.
What's the relevance?
I've been accused of being out of the scope of the LDS religion when this is exactly in the scope of the LDS religion.
All right, I guess to the extent you're comparing yourself to these biblical figures, I'll allow it.
was Elijah translated? Yes, I believe so.
Okay? But you don't know that John the Revelator was translated as well?
I can't remember.
And then the three Nephites in the Book of Mormon, they're translated as well?
No, there were 3. You asked me their names. I don't remember their
I
names.
wasn't asking their names. I said, do you know who they are? As in, are you aware of them? I'm sorry. I'll be more specific. Are you aware of the 3 Nephites in the Book of Mormon?
Yes.
That they were translated?
Yes.
So is it fair to say that that isn't uncommon in the Christian belief system, to believe in people being translated?
I don't know if I'm qualified to answer that question for all of Christianity.
Okay. Are you a Christian that believes in the Bible?
Yes.
Object, Your Honor, to relevance.
I'll allow it briefly, but hurry up and make your point.
Yes, I believe in the Bible, of course.
And Elijah in the Bible is translated, right?
Yes.
And you believe in that, right?
Yes.
And you're a member of the Church of Jesus Christ of Latter-day Saints, is that correct?
Correct.
So that would not be out of the scope of what you believe. That's all I'm asking.
Correct.
Okay, that's all I wanted to know. Thank you. So when we were having this girls' weekend, what else did we do besides one prayer?
I remember going out to lunch, and we went to the temple, and we did service projects.
So we had a typical fun girls' weekend
Yes.
with 5 minutes of a prayer.
I don't remember how long that prayer was.
But basically, out of the 72 hours that we got together, 5 minutes of it we spent actually praying.
Again, I don't remember how long the prayer was, but that was not, from my perspective, the focus or majority of our time spent.
Okay. How long would you say that prayer was? 10 minutes? Longer?
I don't recall.
Okay. But a tiny portion of our whole fun weekend, right?
It was a small portion, yes.
Okay. How many communications have you had over the past 5 years with Christina Atwood?
Many.
Like how many?
Again, I'm not sure how to estimate that.
Daily, weekly, monthly?
Weekly for sure, sometimes daily.
Okay. So would you say over the past 5 years that your relationship has grown with Christina?
Yes.
And are you related now?
To Christina?
Uh-huh.
No, we're not related.
Oh, as in-laws?
No,
Okay, I wondered. I didn't know.
no.
Your Honor, again, I'm going to ask that the defendant be told not to comment about the questions and testify.
Yes, the jury should disregard that comment after the answer.
Are you still in contact with Zulema Pastenes?
No, I haven't had contact with her in a while.
Are you in contact with Kay Woodcock?
Who? I'm sorry?
Kay Woodcock?
I don't know who that is.
Okay. Are you still in contact with Nicole Earl?
Yes,
How often?
often. Again,
Weekly or daily?
weekly, sometimes daily.
Okay. What about Melanie Gibb? Are you still in contact with her?
No, I run into her occasionally, but
You said also in your testimony earlier that I said that I believe I don't need to repent and you were shocked. Is that correct?
Yes.
What did I say to you exactly?
Again, I don't remember verbatim. That was over 6 years ago, but something to the effect of you didn't need to repent. Again, I don't know exactly, but, or we didn't need to repent, whatever it was, but yes, that's what I remember.
What was the context of that conversation? Like, how would that come up? I'm like, how would that come up?
I don't remember what we were talking about or how that subject was brought to the forefront, but it was, I definitely remember that comment.
You remember that coming out of my mouth to you specifically, not from someone else, but from me to you directly.
Yes, and it was, I think, in front of all of us, but I'm not very clear on that. I think it was to all of us from you.
So was I teaching a class that you attended and said something in that regard?
No,
Why would I be the one speaking?
sometimes we take turns when we speak.
Speculation as to why the defendant would be speaking?
I'll let the answer stand. She answered.
You said something about being uncomfortable on that weekend. Is that correct? With some of the topics?
Yes,
Why didn't you just leave if you were so uncomfortable?
I was uncomfortable with some of the topics, but I was still there with friends, and I had flown across the country, so it was not easy to leave, and I didn't feel like I needed to leave at that point.
But you're a grown woman, right? You have your own mind and ideas.
Yes, of course.
So would it be fair to say that you didn't disagree so much at the time, but now looking back on it, you disagree?
I don't think that's a fair comment, no?
And would it also be fair to say that we had a good time of that weekend?
Yes, we did have a good time.
And that now you've changed your mind a little bit?
I'm sorry, I don't understand the question. Change my mind about what?
About what made you uncomfortable?
No, I didn't change my mind.
You had mentioned something about you were interviewed by the police a couple of times. Is that correct?
Yes,
How many times?
twice.
Who were you interviewed by?
The The first time a detective came to my home, his name was Nate Moffett, I think.
Okay. When was that about, approximately?
I want to say spring 2020.
Okay. How long was that interview?
I don't remember.
Like an hour or less, or?
And Your Honor, the witness has already answered the question. She doesn't remember.
Can you estimate how long that interview was?
Well, from my memory, I don't remember it well. I thought it was only a few minutes, but
Okay.
I think it was longer than that, perhaps.
Longer than a few minutes?
Yes.
What about your second interview? Who was that with?
That was with 2 detectives from Idaho
And where did that take place?
in the Chandler Police Station.
And how long was that interview?
That one I remember being longer, for sure, over an hour, perhaps an hour and a half.
And what did you exactly have to contribute to the police for an hour and a half with someone that you have only met 3 times in person in your life?
Objection, speculation, relevance.
Sustained.
What were they interested in you telling them?
And I'm going to object to speculation, relevance.
Sustained.
What did you tell them about me in those interviews?
Objection, overbroad,
Oh,
foundation.
also calls for hearsay.
Yeah,
Sustained.
Do you feel like you have something to offer here today in relation to the crime that I'm charged with?
objection, relevance, goes to the final
Sustained.
opinion.
Ms. Sharp, did you see or hear or personally witness me conspire with my brother or anyone else to murder my husband, Charles Vallow?
No, I did not.
Thank you. No more questions.
Redirect.
You were asked a lot about taking an oath. Do you take that seriously?
Yes, I do.
Is everything that you told the jury here today the truth to the best of your knowledge?
To the best of my memory and knowledge, yes.
So when you don't remember something, you've been asked to try to guess, you don't remember how long something is, but you're not making up things in here.
I'm trying not to. I'm trying to go for my best memory.
It's been 6 years since you attended these meetings, correct?
Correct.
So you don't remember the number of phone calls that you and Lori had 6 years ago?
No, not at all.
You didn't keep tally marks of them through your days, put them on your nightstand so you could remember it later?
No.
How about the text messages? You tally those up for you so later on you'd be able to remember that you had 50 of them or 100 or whatever it was?
No, definitely not.
Are there things that stand out in your memory that you recall very well?
Yes, there are.
Is one of those the fact that Lori Vallow told you that you didn't need to repent or that she didn't need to repent?
Yes.
Was another one of them her telling you that her husband was possessed by an evil spirit that she named Ned?
Yes, definitely remember that clearly.
You were asked about whether being translated was something unusual to you. When you are reading the Book of Mormon or the Bible, are there biblical figures within those books who are translated beings?
Yes,
Was it not something that you had heard people tell you that they were?
correct.
And
I'd never
that's-
heard that before.
So you read about it
Yes,
by prophets and people like that?
yes,
You were also asked about that girls' weekend, and I believe that the defendant said that you did a prayer. Did you have more than one prayer over the weekend? Did you guys pray together?
I can't remember specifically, but I assume we prayed over the food and we prayed, there was probably multiple prayers, my guess.
Is that different than when you guys met to cast out the evil spirit of Ned inside of Charles Vallow?
Yes, it felt different.
So you wouldn't equate a prayer as identical to doing a cast out?
Correct, they are different kinds of prayers.
You were asked about why you stayed there that weekend. As someone who was a grown woman and strong in your faith, did you in fact question Lori when she talked about not needing to repent?
I don't remember how I responded. I definitely pondered that for a while. I remember talking to others. I can't remember if I spoke specifically with Lori about that at that time.
You were, even though that was something you knew not to be within your faith, you didn't just pack up and run away.
No.
Were there other women there that you were also friends with?
Yes.
People who you're still friends with?
Yes.
These women that you are still friends with, is anything about your relationship with them changed the fact that you remember Lori saying she didn't want to repent?
I don't think so.
Like you didn't say, hey, Christina, I feel like just making up something to say against Lori. What do you think we should talk about?
No.
You didn't sidle up to Nicole and say, Nicole, let's make up a story about Charles being possessed by Ned. What do you think?
No.
Those are just your memories.
Those are my memories.
I have no other questions, Your Honor.
Are there any questions from any member of the jury? If so, please pass those questions forward. I'm not seeing any. All right, you can step down, ma'am.
Thank you.
Stake and clerk, next one.
Thank you.
Well, I guess I can talk a little bit, but that was spicy. I loved it. I was enjoying every single minute of it. Absolutely loved it. We are moving through witnesses. We are witness number 10, which is good. It's just yeah, so I think we are getting into
Come right up here and be sworn in. Just stand here.
or
Can you spell your name for the record?
I do. My name is William McDonald, W-I-L-L-I-A-M. McDonald, McDonald.
Thank you.
Order here and have a seat to my left.
Would you please introduce yourself to the jury?
Hi, good afternoon. My name is William McDonald. I am a retired police officer with the city of Chandler.
What are you currently doing?
I am currently teaching criminal justice at Williams Field High School in Gilbert, Arizona.
So you told us you previously worked for the Chandler Police Department. How long were you with them?
I was with the Chandler Police Department for approximately 22 years. I'm sorry, 26 years.
Oh, that's a big difference. When did you retire?
I retired in November of 2022.
Okay. Can you tell us what your different jobs were at the Chandler Police Department?
As with all officers with the Chandler Police Department, I started off in patrol. I worked a patrol position for about 18 months, after which I switched over to more of a community services team. I spent 2 years with that team, after which I transferred to detectives and spent the remainder of my career in detectives, working primarily internet crimes against children and digital forensics.
Can you talk to us about specifically your training and education relating to extractions of cell phones?
When it comes to cell phones, I have extensive training in the use of the software that we use to extract that data. I am certified in the use of the Celebrite suite, which is one of the primary tools that we would use to extract data and organize data extracted from the cell phones. I was also trained, although they did not have a certification process, in several other platforms used with cell phones.
Did you ever go to any type of digital evidence examiner courses?
Absolutely. Beginning in 2001, when I began working digital forensics, I attended numerous courses on digital forensics, hundreds of hours worth of training, and I hold several certifications in digital forensics related to computers and, as previously discussed, cell phones.
So by 2019, what were your duties at that time at the Chandler Police Department?
By 2019, my primary duties were to conduct digital forensics examinations on computers and cell phones. I was also responsible for training new members to the computer crimes unit, in addition to assisting with internet crimes against children investigations.
In your role, were you regularly asked then to examine cell phones and try to extract data from them?
Yes, I was.
Can you talk us through, if you are handed a cell phone, what do you do?
Once we received the cell phone, and we would usually be given additional information at the time, usually from the case agent or the investigating detective, such as if there was a search warrant involved or anything like that, we would review the search warrant, make sure we had legal authority to do whatever it was they were asking us to do. We would then obtain the cell phone or whatever item we wanted to examine. My process was to start by taking pictures of the phone or the device prior to removing it from any evidence packaging. Once those pictures were taken, I would remove the cell phone from the packaging, take additional pictures to document condition of the device. Once the pictures were taken, I would attempt to power on the device to make sure that it had been placed in airplane mode, which would prevent any additional changes being made or outside people being able to access the device to make changes while it was in our possession. If it was in airplane mode, I would then attach it to whatever piece of software or hardware we were going to use to copy or extract the information from the phone. Once that process completed, which you would usually create just a single file, which for most of us would be meaningless. It was just a container file. And by a container file, I mean a file similar to, if you think like a box. The container file is the box. Initially, that box is empty, and we can put additional files inside of it. These container files would then be entered into, usually we would use the Celebrite software, as we did in this case. And that software would kind of go through the box and put everything in an organized manner, a manner in which people could read it and make sense of what that information was. We would then create a report, which we would provide to the case agents, and that would pretty much conclude our involvement. We would finalize everything by taking everything that we created, all of our files, all of our reports, notes, pictures, everything, and we would store them on an archive server at the Chandler Police Department.
All right, going to go through a couple different words you said and have you explain them for us, all right?
Certainly.
So starting with first extraction, what does that mean?
Simply put, extraction means we're copying the information on the phone to another device, say a thumb drive or another hard drive, or something that we have prepared forensically, which means it contains no data.
So when we're talking about extraction from, say, a phone, you're copying contact lists and text messages and photos and emails or search histories, anything that we have on our cell phone.
Correct.
Okay. Can extraction of a cell phone include GPS or locating data?
It can.
When you have extracted this, you talked about it not being in a format that people can understand. Can you talk to us just a little bit more about that?
So essentially, these single files, when we have copied or extracted the information from the cell phone, it creates this single container file where all of the information is in there. That information is in the form of database files, other proprietary type files, that without appropriate software or specific software to actually be able to read that information, it would be extremely difficult to piece it back together manually.
And so that's what you said, the Cellbrite software helps to put that in a way that we can read it?
That is correct.
So when you use the Cellbrite system, does that put the data together, like all of the text messages are now together and all of the emails are now together,
Yes, ma'am.
rather than just being jumbled everywhere, basically?
Correct. It will put text lines together. It will extract date and time information. As you mentioned previously, it can extract GPS and location information. It will extract pictures, and it puts all of those together so that like items are together.
Are you responsible for reviewing or analyzing whatever it is that you extract?
No.
Are you solely responsible for trying to extract the data from a phone, ensuring that that process goes correctly and that it is then parsed into data that lay people can read?
Yes, ma'am. When we extract the data from phones or computers or whatever digital medium we're working with, we follow forensically sound procedures to ensure that that data is not changed at any point along the process.
And so you said you also keep the original data file that you extract in a server so that if anyone wants to look at that, they can do that again?
Correct.
And then the phone itself, does it alter the phone in any way when you do this process? Is it blank after that?
Our process should not change any of the information on the phone. However, with cell phones, because they do need to be on during this process, some system files can change.
So it could add more data to it potentially?
Potentially, yes.
All right, so on July 16th of 2019, did you receive a request from a detective in Clan to examine an Apple iPhone that was impounded as item CH141035? And if I can have my paralegal approach with Exhibit 245?
Thank you. Yes, this is consistent with the item I received.
Were you provided with a PIN to access that phone?
We were.
Okay, and what was the PIN you were provided to access that phone?
The PIN was 0000.
All right, pretty easy to remember. And if you can bring that back. What day did you begin the extraction process?
I believe, if I recall correctly, it was July 17th.
So the next day.
Yes, ma'am.
You told us that you first get the phone and you are both documenting it and sort of noting it. I'm going to show you, and if I can have my paralegal approach with exhibits 180 through 185 that have been shown to defense counsel. Are you familiar with those photographs?
Yes, these are consistent with the types of photographs that I would take.
And those related to this review of this cell phone 245.
Yes.
State will move to admit 180 through 185.
Any objection?
No objection.
180 through 185 are admitted.
And if I can have the Elmo, thank you. Why do you take photos of the phone as you're processing it?
Primarily, we take photos of the phone to document condition. I will also take photographs of the item while it is still in the evidence packaging to document how it was packaged, and if there are any evidence seals, what the condition of those seals are.
All right. So in this, when we talked about a item number, is that what we were talking about, the CH131035?
Correct.
Okay. That's Exhibit 180 and 181. What are we seeing here?
That is a photograph of the front screen of what appears to be an iPhone X, I believe, or XS Max.
So
I'm sorry.
you get this phone, and I put 182, it's turned off initially when you get it.
In this case, this particular phone was powered on when I received it.
Okay, but the screen was blank, but still it was powered on.
Correct.
Was it in airplane mode, and why does that matter?
Yes, it was in airplane mode, and you can see that from looking at the upper right-hand corner of the phone screen where it's got the little airplane icon. And this is important because while a phone is in airplane mode, it will prevent outside sources from connecting in and prevent the phone from connecting to the cellular network or to any wireless networks, which will help secure the data that's on the phone to prevent any changes or from anybody from the outside accessing the device.
Okay. Do you check when you get a phone like this to see if there's a SIM card in there?
I do.
What is a SIM card?
A SIM card is a subscriber, it's short for subscriber identity module, and it's basically a little card that's inside the phone that holds certain subscriber information. It can hold contact lists. It can actually hold a great deal of miscellaneous information. We always check for the SIM card as a means to make sure that this phone is actually able to connect to a cellular network.
Did you see one here?
I did.
And then do you also check to see if there's enough battery power?
Absolutely.
What do you do if there's not?
If we receive a phone that is either powered, has low power, or is actually the battery is completely dead, we will connect it to a power source to recharge the battery. The processes that we do required the phone to be able to be powered on, so we needed a charged battery.
All right, so in 183, you are able to get to where you would normally put in a passcode. Do you sometimes not have passcodes?
Absolutely.
Is it easier when you do?
Much easier.
So did you try the 000 here?
We did.
0, I think I left one out. Were you able to get into the phone?
We were.
184, why do you take a photo of that?
We're just documenting what is visible on the screens, what icons, what applications are installed on the phone.
So you're seeing that there have been phone calls that have been missed and mail that's
Correct.
going on. And then 185, what is the relevance of this? What does this tell us?
That is simply information on the phone itself. What you are looking at, if it were able to connect to a network, you would see the network information there. This is obviously a phone that was associated with the Verizon cellular network. The IMEI and the ICCID and MEID are identifiers for the cellular networks. The network, the carrier, and all of that information is just to help identify the device.
Okay. And so that is able to be confirmed when you look at the phone itself, 245?
Correct.
So in this case, after you got this powered up, what'd you do and took those photographs, documenting what you're doing, what'd you do?
Once we had taken the photographs, we'd ensured everything, the phone was in airplane mode. In this particular case, I used a device called a gray key device. I attached the phone to this gray key device and configured it to conduct what is called a full file system extraction of the iPhone. A full file system extraction is pretty much the best copy that we can make. It copies all the data off the phone, including anything in deleted space, any user files, any system files. It pretty much copies everything that's on the phone for us to examine later.
Okay. Now, Does technology continue to improve in our world?
All the time.
So you did this in 2019, right?
Correct.
So whatever the newer technology is not the same as what it may have been back then.
That would be fair to say, yes.
In terms of technology, have you seen changes in Gray Key and Celebrite over the years that you were using it?
I did.
And as each new version came out, did that ever cause you to find that data was wrongly recovered, or just that there was more data recovered?
In my experience, I never observed that changes in the software, updates to the software, would result in previously found data being changed or omitted or deleted or in anything like that. What we would find is it would change the format and how that information was presented. On occasion, as things really did change and bigger versions came out, sometimes it would have the capability to acquire additional information that maybe it could not acquire prior.
So maybe it was better at finding deleted items or parsing things together.
Correct.
Okay. Do you recall about how long that process took to use the Gray Key to extract that full file system?
As I recall, it was approximately 1 hour.
So after you use the Gray Key, is that where sort of everything's jumbled in a box?
Correct. That's the Gray Key created that single container file with everything from the phone inside of it.
So did you use something else at that point to allow detectives and other people to be able to access and look for specific things?
I did. Once we have that single container file, I took that file and I opened it up in a program called Celebrite Physical Analyzer. That physical analyzer software is what went through that container file and put everything in a more readable format for detectives or whoever else needed to view the contents of the phone.
So that then allowed detectives or others to go into this new report that allowed you to look at a section that had just photos or a section that just had emails.
Correct.
After you used that Celebrite to parse out all that data into these different sections, did you conduct any research on that phone? Or
I did not.
did you look through any of that Celebrite report?
I did not.
Did you analyze or review any of the data?
I did not.
Did you provide the detectives who then had been working on the case with that to review themselves?
What we would do, since the Celebrite Physical Analyzer software was very expensive and actually required a key in order to use, the Celebrite software allowed us to create what we referred to as a reader file, which is a file that they can open in a program called Celebrite Reader, happily enough, and that would allow them to review the data in a free software platform.
So as long as you had the reader, you could then go through all the data that the Celebrite had parsed into these readable formats or
Correct.
sections.
Anything that was included in when I imported the file or uploaded the file into the Physical Analyzer software, any information that was in the Physical Analyzer software was copied and included in the reader file.
Did that end your involvement with Exhibit 245, that phone?
I'm sorry, one more time?
Did that end your involvement with Exhibit 245, that iPhone?
Aside from making sure that any files that we created, any pictures that were taken were securely stored, it did.
All right, thank you. I have no other questions.
Cross?
Questions, Your Honor?
I'm sorry, did you say no questions?
No questions.
All right. Any questions from any member of the jury? I see at least one, okay.
Wow. While they talk about jury questions, I need to wake myself up. Literally, she did not ask any questions because it's information that goes like right above her old face. I absolutely agree. Wow, indeed. Well, it was so nice to see you, my friend. Oh yeah, definitely. She definitely could not keep up with that talk. She was like, huh? What's he saying? I don't understand. Oh man, yeah, this is definitely a way above, like meow, right above like the. Let's do a dance break. Bing bing zombie walk. I need to do songs. Hang on. So my ideas for the song is zombies, and then one about
The
Lori's
question is,
Rose.
if someone were to delete their browser history, can you still pull the history?
On occasion, browser history and any internet data like that, especially on cell phones, over time, if it's been deleted, it can be overwritten. However, if it is more recent, and sometimes by recent, we are actually talking within the last year or so, that information, regardless of it being deleted, can be recovered by the software.
Follow-up from the defense based on that question?
No.
State?
No, Your Honor.
All right, sir, you can step down. Thank you.
Thank you.
State can call its next witness.
Thank you.
Wow, we'll go to witness number 11. Ding, 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 ding. 10 more witnesses that the state has to go through more, because they have, well, 21. So I'm counting down witnesses now as well. I don't know how to spell the next name. I know, but I think I misspelled it by by writing it down. I think, yeah, I think definitely. Yeah, there you go. What do we need, a tech expert? I definitely can see that nomination, and I'll nominate Iowa as our tech expert for sure. Agreed.
State calls Marissa Francisco.
All right, ma'am, you're going to come right up, stand right in front of the wall here, right here.
Please spell your name for the record.
Yes, Marissa Francisco, M-A-R-R-I-S-A, last name F-R-A-N-C-I-S-C.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Thank you.
All right, you're going to walk around the court reporter. Have a seat just to my left here.
Would you please introduce yourself to the jury?
Yes, my name is Marissa Francisco, and I am a forensic scientist with the City of Chandler in the Forensic Services section.
How long have you worked there?
I have worked there since August of 2018. Previous to that, I was employed at the Arizona Department of Public Safety, and I started there in 2004.
So let's kind of go back. What did you do at the Department of Public Safety, DPS?
I started my career in the blood alcohol unit, so my duty there was to test blood for the presence of alcohol. I was in that unit for about 7 years. After that, I transferred to the trace evidence unit, where I was trained to do hair comparisons and fiber comparisons. After that, about 2016, 2017, I started training in the latent print unit. In August 2018, I completed my training at the City of Chandler and have been doing latent print analysis primarily at the City of Chandler.
Can you tell us the training and your education to be a latent print analyst?
Yes, I have a Bachelor's of Science in Biochemistry from the University of California at Los Angeles and a Master's of Science in Forensic Science from the University of Illinois at Chicago. As part of my training for latent prints, it was an extensive 1.5 year long program where there was readings, lectures, comparison exercises, oral boards, and a competency test. I also have to conduct and complete a proficiency test on latent print comparisons on an annual basis. I am also a certified latent print examiner. In order to obtain the certification, I had to complete over 160 hours of certified training and pass a comprehensive exam.
Thank you. I'm going to start sort of really general. Can you tell us what latent prints are?
Yes. Latent, by definition, is something that is present but not visible. So a latent print is an impression of friction ridge detail that is not readily visible. Some processing techniques that can be chemical or physical are needed to help visualize those latent prints.
So we talk about latent prints, we're thinking of people's fingers. Where else do we find latent prints on people?
Yes, let me start with defining what friction ridge skin is. Friction ridge skin are raised ridges on the palms of our hands and the soles of our feet. They are specialized and only located in those two areas. We often have oils and sweat and other residues on our hands, and when we touch an item, we can leave an impression of our friction ridge detail on that item.
Is that what most of us call latent prints, or I left a print behind?
Yes, fingerprints.
You started to talk about oils and things. Do people always leave behind a print if they touch an object?
It actually depends on a lot of different things. First off, the amount of oils and residues on our hands will determine whether an impression is left. Also, the deposition pressure, meaning are we gently tapping on something or are we like really pushing down on it, that will affect whether an impression is left and the quality of that print. The item itself is very important. Is it something that is receptive to prints? Items that are smooth, like glass, I am more likely to find a print on an item like that versus something that is textured and rough, like a cinder block. I would not expect to find a latent print on a cinder block. The condition of the item is also important. How many people may have come in contact with that item. All these different things affect whether an impression is left and the quality of that impression. We can very simply think of a stamp, our fingers being the stamps, the oils being the ink, and depending on how the stamp is placed on different items will determine how that impression looks.
Can environment also impact the quality of, or whether or not a print remains?
Yes, the environment is also important. After a print is left, is it left out to the conditions of rain, or does it get wet? Is there a dust storm? Is it in an area that it has high traffic? Like if a fingerprint is left on a door to a convenience store and 100 people go through there that day, impressions are left, but if I lift those prints, I might not be able to identify them because there are so many prints on top of each other.
And so that goes to the next thing. So are prints something that once you make it, it's permanent and there forever?
It is there until it is disturbed, so it can be there forever.
Can we wipe them away?
Yes,
Can they be smudged away?
they can, yes.
So can someone rubbing an object, like a smooth object, get rid of that?
Yes.
Are there different ways or different processes that you use to obtain latent prints or friction ridge detail off of an object?
Yes, there are. First off, I want to define what a non-porous item is. A non-porous item is an item where water or air cannot pass through it. So when I first receive an item, I determine whether it is porous or non-porous because depending on that, I will use different processing techniques.
So for a non-porous item, what processes do you use to try to find friction-rich detail?
Yes. On non-porous items, the main processing technique that I use is called cyanoacrylate fuming, more commonly known as superglue fuming. So items are exposed to superglue fumes, and the fumes react to any oils and sweat in the latent print, creating a white visible print that is not readily destroyed.
So you've looked at the non-porous item, you don't see any prints on, do you look visually first?
Yes, sorry. The very first thing we do is I look at the request sheet and see what items are needing to be tested in that case. And also I look to see what the requesting officer wants done with the case. Sometimes they are requesting that the item be swabbed for DNA. If an item is requested to be swabbed for DNA, I have to use clean techniques to help reduce and limit contamination. So clean techniques are when I bleach down all surfaces with bleach, I lay down a clean butcher paper, I use sterile equipment. I'm only analyzing and working with one item at a time, and I'm changing gloves between items to help prevent contamination. So if a request sheet requests DNA evidence, I will have to use clean techniques before I swab the item for DNA. After that, I will do a visual examination of the item. Before any processing techniques are conducted, I will take a flashlight and look at the item to see if I can see any latent prints with a flashlight. If I can see a visible print at this point, depending on the quality of that print, I will take a picture or lift that latent before I move on to any processes. So after each processing technique, I will have to document what I find with either photography, scanning on a scanner, or lifting with powder.
So you talked about photographing these latent prints. How do you do that? Like how do you take a photograph of that to ensure it's the right size or shape or whatever, so you can later use it for a comparison?
Yes, I have training and experience in taking photographs. So in the photograph, I have to have a scale in it. So I have a scale with the case number, and I am just trained to properly use the lighting I need, adjust the lighting, focus it correctly, have it level with the lens of the camera, and I take a picture and document where on the item the photograph was taken.
Okay. So how do you just told us you document where on the item the picture was taken. How do you do that so that you can later go back and say it's in the middle of a mirror or whatever it might be?
Yes, I try to be as clear and concise as possible because, like I said, I have to take a picture after every single step. So I have to take a picture if there is any latent print at the visible step, and then if I go on to doing the super glue fuming, I have to take a picture of that same latent. If I go on to another process called dye staining, which we apply our fluorescent dye to even better visualize the image, I have to take that same latent again. So it helps me out to be able to find that latent. So I try to be specific on where that latent was found.
Do you, when you are processing a non-porous item and you find what I'll call a partial print or something that looks like friction-ridge detail, do you collect it or do you say right then and there, I don't think that would be useful?
Yes. So when I am examining an item, at that stage, my conclusions are either no latents observed, meaning I didn't see any friction ridge detail at all, no value latents, meaning I did see some friction ridge detail, but I don't believe that I can do anything or compare them at a later point, or latents for analysis. So if I find sufficient, clear, latent print detail, I will take a picture of it. If I'm not sure, I go ahead and take a picture of it, because at this point, I am not really determining whether the print is identifiable. I am just saying that I'm taking this picture and I want to do further analysis on it at a later point.
So then for the analysis, are you then, after you process an item and you recover any latent prints that may be useful or which are you later asked to ever compare those recovered prints to known prints?
Yes.
What do we mean by a known print?
Yes. So a known print is known fingerprints that are collected from an individual. They're typically recorded electronically or with ink. So in my comparisons, I am always comparing a latent impression that was recovered or developed versus a exemplar, and I'm trying to determine whether or not the latent could have originated from that exemplar, or whether or not those two impressions could have been made by the same individual.
Can you tell us briefly, when you are looking at this recovered latent print and comparing it to a known, what are you looking for to be able to make an identification?
I will explain what methodology we use for latent print comparisons. It is called ACE-V, which stands for Analysis, Comparison, Evaluation, and Verification. So in the analysis phase, I'm taking an assessment of the latent and the exemplar and determining whether or not they are suitable for comparison. If I determine they are suitable for comparison, I move on to the comparison phase. This is when I'm observing two impressions and I'm looking for the existence of similarities, differences, or discrepancies. Next is the evaluation phase. At this point, I am rendering a conclusion based on my analysis and comparison. The three different conclusions that can be reached are identification, exclusion, and inconclusive. So identification is the determination that the two impressions originated from the same person. Exclusion is the determination that the two impressions, the latent and the known, were not created by the same individual, or they do not have the same source. Lastly, I have a conclusion of inconclusive, and this is where I can neither identify nor exclude the individual from having made the print. So going back to analysis, during the analysis phase, I am looking at a lot of different things. First off, I'm trying to determine, is the print from a finger or is it from part of the palm? And also I'm determining the orientation of the print. If it's from the palm, I can also, depending on the ridge flow in the latent print, I can determine what area of the palm it came from. I'm looking at the shape of the impression. Like sometimes you have like a C-shaped impression, and that's this part of the palm. So this is called the writer's palm, and that's where I would look first when I'm doing a comparison. So besides that, I am looking at level 1, level 2, and level 3 detail. Level 1 detail is the actual flow or pattern of the ridges. Our fingers have 3 main patterns, which are loops, whorls, and arches. Next, I'm looking at second level detail. I'm looking at the ridge characteristics. So I'm looking at where the ridges end, which we call ridge endings. I'm examining where ridges split into two ridges, which are called bifurcations. And I'm marking any dots, which are very short ridges. So I'm examining the latent and I'm marking up all these second level details so that I can later compare to the exemplar. I'm also noting if there's any scars present in the latent. I'm noting if there's some creases or if there are issues with the deposition pressure or if there seems to be some movement in the latent. I'm documenting all of that stuff in the analysis phase of my analysis.
Take 249.
Do you
Leave that with her.
Okay.
Yeah. You recognize Exhibit 249 as an item that you were provided and asked to process to see if you could recover any latent prints or friction ridge detail.
Sorry.
I know, it's a little awkward.
Yes, I do recognize this item.
And were you provided with that Exhibit 249, that bat, and asked to try to recover any latent prints from that bat?
Yes, I was.
Can you tell us, in this Exhibit 249, what did you do to attempt to recover any, and did you recover any latent prints?
Yes, on the request, it was also requested that I process the item with clean techniques because it was also requested that I swab the item for DNA. So I already went through that process and explained that. So I used clean techniques to process this item. And the very first thing I did when I opened up the packaging was I swabbed the textured grip for potential DNA. The reason I swabbed the grip first is because of the texture on that grip, I would not expect to find latent prints on the grip. So I didn't feel that I was potentially ruining any prints because I don't feel that there would be fingerprints on that textured grip. So that was the very first thing I did. And then I did a visual examination of the bat with a flashlight to see if there were any visible prints at that point. And I don't believe there were, but I would have to check my notes.
But looking at your notes, help refresh your recollection as to whether or not you did find anything there.
Yes,
Do you have your notes up with you?
yes.
If you want to take a look at those and then let us know when you're done if that has refreshed your recollection. Did that refresh your recollection?
Yes, so at the visible stage, my conclusion was that there were no latents observed at the visual stage.
I'm going to put Exhibit 35 up here just so that we can all kind of see what we're talking about. So the gripped part here is what you were talking about that you swabbed because you did not believe that prints would be recoverable on that texture that was on bat?
Correct.
Okay. So then you visually look, you don't observe any latent prints or friction ridge detail?
Correct.
What did you do next?
I then used a processing technique of superglue fuming.
And when you used that process, did you locate or recover any latent prints or friction ridge detail?
Yes, I did.
Can you tell us how many and where?
Yes, I recovered 2 impressions that I took pictures of, and I would have to look at my notes to refresh where they were collected from.
If looking at your notes would help refresh as to where you located those, please do so, and then let us know when you've been refreshed.
I'm ready.
Where did you locate those 2?
The first one was recovered in the W of the Rawlings that was above the diameter. I think Rawlings is also on the other side. So that's why I stated that it was the one that was right above where the diameter is. And the second one was recovered in between the G and the diameter.
Now, you told us that what you are recovering isn't always look like a finger, right? When you were recovering these latent prints, were you able to tell by just recovering them if it was a finger or, like you told us, a palm? When you looked at it, were you able to immediately identify where they came from?
They appear to be fingerprints.
Was there anything about the shape or, I guess, the shape of them that made you think that they were fingerprints?
The first image, it was just the shape of the impression just indicated to me that it was a fingerprint. The size of it indicated to me that it was a fingerprint.
Was the other one, the second print, slightly, I guess, not as clear on whether or not it was a fingerprint or potentially from some other area?
Correct.
Okay. Were you asked to then compare those 2? Well, let me ask you, when you obtained these 2, you told us there were 3 different levels. Obviously, you collected something. Did you believe these were able to make identifications, or what did you determine about the clarity, the detail of those 2 recovered prints?
For both impressions, in my analysis, I determined that both impressions were NVID, which stands for no value for identification. This means that the latents lack sufficient clarity, quantity, and or uniqueness to identify, but may be suitable for exclusion. So the impressions were possibly excludable, but I would not be able to identify who made those impressions.
So were you initially asked to try to identify them to 3 individuals?
Yes, I was first asked to compare the 2 impressions to 3 individuals.
And who were those 3 individuals?
Could I look at my notes, please?
Yes, if that would help refresh your recollection.
Yes, I was initially asked to compare the 3 impressions to a Charles Vallow, a Lori Vallow, and an Alexander Cox.
So you told us, though, they were of no value for identification. So did that sort of end that request?
Yes, so when there is only prints that are determined to be no value for identification, we routinely do not compare those prints, but we say, if you still want us to compare it to anyone, please let us know. But initially, we are not going to try to compare NVID prints to any individual because they cannot be identified.
So did you then, were you then requested to see if you could make any exclusions?
I was then requested to compare the two impressions to Charles Vallow to see if I can determine whether the two impressions did not originate from Charles Vallow.
Starting with the first impression that you found above the W, but the other side of the bath from what we see in 35 here, where there's a diameter marking. What were you able to reach any conclusions in looking at the prints from Charles Vallow and that recovered print?
Again, I went through the ACE-V process, and during the comparison phase and evaluation phase, I determined that the latents or the first latent was inconclusive to Charles Vallow, meaning that I could neither identify nor exclude him from having made the impression.
So does that just mean there's just not enough in that print to do anything with?
Correct. So it lacks sufficient agreement in the detail to identify, and it lacks sufficient disagreement in the impressions to exclude.
And is that common when you have a latent print that just doesn't seem to have the level of detail just necessary for that?
Yes, that is a common conclusion.
So you're not saying it's Charles, you're not saying it's not Charles, you just can't do anything with it?
I could neither identify or exclude Charles Vallow.
So for the second print, did you also attempt to compare that to latent prints from Charles Vallow?
Yes, I did.
And were you able to reach any conclusions as to that?
Yes, my conclusion was that the latent was inconclusive to Charles Vallow due to lack of detail in the latent and exemplar.
Were you ever asked to try to exclude Alex Cox as having made those latent prints?
No, after I initially did not compare the latents to the three individuals on the named comparison, I was only asked to compare the two impressions to Charles Vallow.
So you also weren't asked to try to exclude or secondary compare to a Lori Vallow?
No, I was not.
And were you ever asked to compare to a Tylee Ryan?
No, I was not.
Did that sort of end your processing and comparisons of this bat?
Yes.
Thank you. I have no other questions for this witness.
Cross.
I have one question. You said earlier that the DNA that you collected, was that ever tested?
I don't know.
Is it sent somewhere else?
Correct. So
Okay.
the city of Chandler does not have the capability to test for DNA. Anytime we swab for DNA, we send it to the state lab for analysis.
So you swabbed it and sent it to the lab, and that was the last you heard of it?
Yes.
Okay. Thank you, that's all.
Any redirect?
No, Your Honor.
Any questions for this witness from any member of the jury? I don't see any, so you can step down, ma'am. I think this is a good time to take our afternoon recess. We'll be at recess for 15 minutes. Please remember the admonition.
All rise for the juries. All right. Break time, 15 minutes. So they will be back at 7:45 p.m. Eastern time. So, of course she did. I know, it's very sad, Sherry. The wine is all gone. Oh, it's 6:45. Where am I? Oh my days. I'm ahead. Sorry, it's the wine talking. We're done at 6:45 Eastern, so we can chit chat a little bit. I do No, don't worry, Mel. Please. Okay. I'm gonna say something so you guys can do now during the break. Go make popcorn. I beg out of you, if you have popcorn, snacks, whatever snacks you want to ask, you want to do it, you want to have, go grab them. Whatever you do, don't fall asleep. because I am saying something. The next witness, the next, if you can, I'm not saying you have to Postmates it, Instacart it, whatever, because the next witness is gonna be Kay. Kay Woodcock will be the next witness on a stand, and I'm telling you, Lori has taken notes. So, I've anything. Kay Woodcock is next. So grab it. Grab any snacks, any food that you want, anything. So it is gonna be good because if we get the cross today, it's get candy. I'm gonna. Kay Wood is the the former sister-in-law of Lori Daybell. Lori Vallow Daybell. Yes, indeed. So they are the grandparents, the biological grandparents of JJ Vallow. So it's Charles' sister that's gonna be next on the stand. So go grab anything that you want. Obviously, probably the first like line is gonna be normal ding bing bing bing. Indeed, Charles. So this gonna be spicy indeed, Willow. So it's gonna be epic. So go grab anything and everything, any food that you have, go grab it. Now it's the time. You have some time to do it. So yes, indeed, she was the one on the policy for when Charles was unalived. So this is gonna be good. Take your pee break, for example. Now, exactly, that is true. Do everything you gotta do. Do calls, do emails, do literally everything that you have to do right now because Kaywood, when the cross starts from Kaywood, that is gonna be epic. They like literally do everything that you have to do now. Do it. I like it. I am trying. Like, the thing is, I don't know how long the direct is gonna be. If we even gonna have the cross today, I wonder because I don't know how long, but I don't think it's gonna be that long of a witness. No witness so far has been that long, really. So there is a very high possibility that we are going to get the cross today. Otherwise, we're going to have to wait until Monday for cross. Because remember, this court doesn't work on Fridays, this trial. So if we don't get the cross today for Kay, we're going to have to wait 3 days until cross comes. And I don't want to wait that long. It is gonna I am so excited. I'm sorry. This is like little Christmas time. When we get witnesses like this, it's like literally Christmas time for me. So I am very excited. I'm trying not to be loud because Garden Bot is literally sleeping at the moment. So I'm trying to be considerate, but I am so excited. I cannot wait. I am excited to pickles. It's but so far, I mean, if what with Serena she got spicy, and with Adam she got spicy. I can't imagine how she's gonna get with a former sister-in-law with Kay. Oh man, sometimes I wish the court was not on in the half an hour delay because knowing that I don't think it's happening right now, but it's oh Pickles is so funny. I was like, I don't like the sometimes the 30-minute break delay. I love it for the fact that I get the correct spellings of witnesses and I don't make a mess out of that. But oh yes, indeed, Case is a force for good. Reckon, yeah, definitely. She's been waiting. Oh, sorry, Sherry, you retargeted, but it's okay. But it's absolutely, she's been waiting for this a long time, and finally she gets her day in court. What's that emoji? Oh, this I like that emoji. Pickles, that is funny. So it is. Oh no, it's okay. Wine fingers. Oh, that's hilarious. I am so excited. I know that we're still gonna have to go through the boring process of the cross, but it's gonna be good because it's gonna be worth it. It's all right, no worries. Um, Oh yeah, she indeed has been waiting for a long time, for sure, Sherry. I agree with you. And you could see it's like she's gone and now after this, but how much do you want to bet, right? Okay, we can bet right now. Oh yeah, she will be fine, but it's gonna be great to see Lori like, being like a Bambi when starting to walk, like going but I'm gonna say I think she knows she can do that because at the end of a testimony, witnesses are released out of subpoena and they can stay in the courtroom. I think she's gonna make on purpose that Kay won't be released from subpoena, that she's gonna pretend that she's gonna call Kay again on her defense, right? So she cannot sit in a courtroom or watch the trial anymore. But yeah, so oh yes, yeah. Definitely pickles. Go now. Go now, now, now. Absolutely. Do everything you have got to do right now. Oh yeah, definitely indeed she does, Robert. Absolutely. Um oh yeah, it was like wow, whoa, whoa. Definitely. I was like into like definitely. She does indeed. I was like, but sadly, I think Laura is going to be petty enough and do that to keep her under subpoena. Um, so she can't be in the courtroom until the very end of the trial. So she can't watch what's happening or anything because I think she's petty enough to do it. And oh, excuse me, and she knows she can do that. So it doesn't yeah, so Kate is not there, which is sad in a way. I, I know it would be a mean move, but coming from Laurie, I expect everything coming from her. It's the Laura's that type of person that you have to be ready for everything and anything that they can come from her. Nothing coming from her should really surprise us because it's Laurie. It's the type of person that she is, and you should be ready for that. And I think I am ready for that. For doing, yeah. So she's not a nice person anyway. So oh yeah. I don't know. She was very very thingy with Serena. I don't know. She was very spicy with Serena. I don't know, Denise, but I don't. Well, I haven't seen anything. I don't want to spoil it, and I'm not gonna spoil it. But I haven't seen anything on Twitter about it because I'm literally getting notifications from everybody that is in a courtroom right now over there. But I don't know. I think she will get spicy because she's losing exactly like exactly well, Serena was, well, it wasn't family, she was the sister-in-law but not in the inner circle. So you know what I mean? So um so it's just yeah, so it's just crazy. So there's no like, yeah, I'm trying not to spoil because obviously we said we're not gonna spoil, but yeah. And I don't, that's the thing, I don't know even if the cross is gonna be today because I mean it's not close, but we are about an hour and 20 minutes away from the day finishing. So we'll see how long because this is going to be a very like important witness to lay a lot of foundation for a lot of stuff that was going on because Kai would know every single, almost every single thing or every single thing that was going on with the whole situation, being the sister of the victim. So oh yeah, she's gonna lose it at some point for sure, either when Kai's testifying or with somebody else. um Definitely. She's almost already losing it. And but what I think as well, right, is that this judge, he should be a little bit like more forceful to Lori. Then but it kind of leaves her a little bit Oh yeah. Oh, can you imagine if she approaches like Nancy Joe? Woo, that's definitely gonna be a very good spicy across there. Absolutely. So we have about 5 minutes to go until we are back in court and we start hearing Kay. But I'm really excited because Kay Wood deserves justice for her brother. She's already got justice for her nephew and niece. No matter what, Kay Woodcock always was very fond of Tylee and JJ. So I think, in my opinion, so she got justice for them. Now we just need for Charles, and then after for Brandon for sure. But yeah, so she might lose her mind, and I hope she does. And I want to watch it, and I want to record it, and I want to post on TikTok, on Shorts, and on YouTube too. But absolutely, because yeah, I definitely want that to happen. I'm sorry, but this trial is all it's gonna be. So, I'm not mean. I am not a meany person. I am a very kind person, Zio. Hello. I will reply to you in a second, darling. I'm kind of busy. Glad that you're here because I was going to text you and say that it's going to have to get spicy up in here because it's. Tú no hablas inglés, que puedo hablar en español, no has problema. So, hey, Robbo says, hello, Zio. Like waves at you and with a pink heart, obviously, but it's basically hello. I was like, it's the anticipation for this trial. It is for getting justice for Charles above anything else, but it's also to see the spectacle that Lori put on for sure. So. And I am here for it too. Girl, I was just like, this afternoon, I've been so busy trying to see the verdict, the closings for the trial that has been long as everything. So it's just crazy. Oh, talking about that. So, tomorrow, my goal is that, hang on. I do actually need to write where we left off. Um, uh, we left off. Fuck, I don't even know how to look where we left off, but okay, I'll check it later. So tomorrow my plan is we start stream at 9 a.m. Eastern. All right, we carry on with the closings of Linda Stermer. We're gonna carry on with them, watch the rebuttal while they are already doing jury instructions and start deliberating. That's probably what's gonna happen. And then we can do a bit of parole hearings and see how things go. And probably just do that throughout the day. Or I might do is just do closings until the time that they go deliberate, end the stream there. I have a bit of a free time while they're deliberating, and then go live again when verdict comes. What do you guys think? Which prefer, like, say either one or two. So one is watching parole hearings, and two is me coming back when there's a verdict, coming back live when there's a verdict. What do you think? What do you want to do? Because there's no Lori, and obviously we're not going to start a new trial or anything like that. But we still need to finish the closings to like wrap up with a bow. I will do a poll. Thank you, Sherry. Where's polls? Can I even find the polls after a glass of wine? Do, 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 do. Do you want to watch parole while on verdict? Hang on. What you wanna? Hang on. I need to think. Else, like, what you want to do on verdict watch. On verdict watch. Parole hearings. Oh. Or come back when verdict. Right, there you go. There's the Yopol. There's spelling mistakes, but it's me. Hey, that was quick. Nice. Oh, enchiladas. Oh, pickles. Why do you always make me hungry with the food that you do? Like, I was CSD Dog's mom, but obviously because they're still gonna be doing closings and jury instructions and everything, we we need to finish that off. We need to wrap a bow. So I want to complete that. I am a bit of a you're making tortas de milanesa. I don't know what that is, but it looks amazing and sounds amazing, and I want it. Please and thank you with the cherry on top. I know, do not harm. I understand that, but we haven't finished the closings or the rebuttal or the jury instructions. So we need to do that at least. I know, Zio, and I will rest. But here we go, court is back. But I have this thing of completion that it's gonna make me wonder. And Paula needs something to listen to while she works. So, somebody got you is cute, but you're funny. I appreciate you guys. Oh, you guys are amazing. You're so supportive. Oh, wings homemade. Ouch. That sounds nice. Oh, sorry. Court is back.
All rights to the jury.
Yeah, but sorry, I thought. I know you listen at work. Yeah, I know. Definitely, absolutely understand you. I need that for my sanity too.
All right, please be seated.
We need
We're
to
on
get
the
to
record.
1K.
The jury is present. State call its next witness. All right, ma'am.
You do solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, go and have a seat to my left.
Would you please introduce yourself to the jury?
My name is Kay Woodcock. Charles Vallow's younger sister.
How old are you?
How old am I today?
Today.
64.
And are you married?
Yes.
Where do you currently live?
Lake Charles, Louisiana.
I want to talk to you about your siblings. You told us that you are Charles's sister. How many siblings were there in your family?
6.
And where did Charles fall into that?
He was number 3.
Who are the other siblings?
My oldest sister, Terry, then my next sister, Susan, then Charles, then Jerry, then me, then Bobby.
And where did you guys grow up?
We're in Lake Charles.
Were you close with your brother?
Yes, I was.
Did you know his wife, Lori Vallow?
Yes, I do.
Can you point her out in the courtroom and tell us what she's wearing?
She's the defendant over there in the black jacket.
Your Honor, may the record reflect the witness has identified the defendant.
It shall.
I want to talk to you sort of about Lori and Charles. Were you at their wedding?
No, they went to Las Vegas.
Do you recall what year they got married?
2006.
Did they have a reception that,
I don't know if that's what you'd call it, but there was a family gathering in March of 2006 at a ranch in near Austin, Texas, that we all went to.
okay, kind of to celebrate that?
Yes,
Had your brother Charles been married before?
yes,
Did he have any children from his prior marriage?
yes.
How many?
2,
And who were they?
Cole Vallow and Zach Vallow.
And did you know if Lori had any children from a prior marriage?
Yes, Zach, Colby Ryan and Tylee Ryan.
When Lori and Charles got married, did Charles's 2 sons live with them?
Live with Charles and Lori?
Yeah.
No.
Did they stay with their mother?
Yes, they did. They visited, but they never lived there.
Where were they? Was that in Arizona or still in Texas?
In Austin.
I want to ask you sort of some of the ages of the children involved. In July of 2019, was Tylee still a minor?
Yes,
So she was still living with them.
yes,
In July of 29, do you know if Colby was still a minor?
yes. Oh, wait, no, Colby was not.
He was an adult at
He
that
was
point.
an adult.
And in July of 2019, were Charles's 2 sons, Cole and Zach, still minors or adults?
They were adults.
Okay. Did Charles and Lori have any children together?
They adopted my grandson, JJ.
And can you tell us how that worked out?
How that worked
Or
out, meaning
how did they get involved in adopting your grandchild?
Charles approached me about it one day. He called, and I mean, there was a lot of stuff going on then, and that was my son's child, and there was a lot going on. So I just told him then, look, I can't make a decision like that. We don't know how this is going to go. Just, well, just keep me in mind, keep it in mind. And so I kept it in mind.
And do you recall, when did they adopt JJ?
It was final in July of 2014.
How old was he then?
He was 2.
Did JJ have any special needs?
Yes, he was autistic, and he was born 10 weeks premature.
Okay. So he took a little extra care.
He did, absolutely.
Do you recall, so if he was 2 and they adopted him, how old was he in July of 2019?
He was 7. We spent his 7th birthday together in Lake Charles.
So in July of 2019, to your knowledge, Lori and Charles still had 2 children under the age of 18 with them, Tylee and JJ?
Yes,
So if in July of 2019, Lori Vallow was saying she had 5 kids she was taking care of, you were unaware of the other 3?
there were not 5 there, no. There were 2.
Can you tell us about the relationship between Charles and JJ?
Charles was the best dad. I mean, he was always doting on him. The arrangement I figured out eventually was that if Charles was working out of town, Lori had him all by herself. And so when Charles got back to town, JJ was his to take care of, 100%.
Would Charles bring JJ to visit your side of the family in Louisiana?
Oh, yes.
Did you regularly see him?
Yes, once JJ learned how to fly, and, excuse me, I need water. Once JJ learned how to fly, and, that because he was autistic, something like that, is, you know, a big deal for him, and he loved it, so he was a little flyer. He loved to go in the airplane.
What did your brother Charles do for a living?
He sold annuities. He was a financial planner.
And how long did you know him to do that?
If I had to guess, 20 years, I guess.
Did he work for others or have his own business? What do you recall?
He had his own business.
Had he previously any times ever worked for others?
Yes,
But in July of 2019, he had his own business.
yes.
Did he have a business partner?
He did, yes.
Did his job require him to travel a lot?
He did. He would be gone 3 or 4 days a week, on average. Sometimes he didn't have to travel, but he was just, but yeah, he would be gone 3 or 4 days a week when he would be working.
I want to ask you a little bit about Charles. Was he sort of a meticulous person when it came to paperwork?
Oh, yes. I mean, for when you're doing that type of work, you have to be meticulous and methodical, and you can't make any errors. You can't miss a dot or crossing a T, because it will get kicked back to you, and then it just causes a lot of delay and a lot of trouble. So he was actually, he said, there was never anybody I've ever trusted to do this for me. And I was like, well, I'll do it for you, because,
All right, we'll stop here.
yeah.
So when Charles was working as financial planner, do you know if he had Lori help him with any part of his job?
I don't really know exactly what she did, but yes.
Okay.
But I don't know what she did.
Prior to Charles being a financial advisor, did he have a very different career in sports?
Oh, he was, he quit, I don't know if, I don't remember because I was quite young then, but he did, I believe he was drafted in the early 70s into the Houston Astros minor league.
So when you were growing up, did you see your brother playing baseball?
I was raised at a baseball field. If it wasn't Charles, Jerry played for years, my other brother, but Charles stuck with it, and that's how he got to college with a degree, with a scholarship.
So you got stuck many a night and a weekend having to be at the ball field with your brother?
Yes.
What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Left-handed? After your brother, well, let me ask you, do you know how long he played in the semi-pro?
I don't, he had moved to Houston, and, but he blew out his knee, and that's ended that right there.
Did your brother stay in shape after that, even though he blew out his knee?
Oh, yes, he was always doing something, always, bike riding, hiking, just anything. Gym, he was very active.
So every time you saw him, he was taking care of himself?
Yes.
I'm going to ask you a little bit about religion. Did your family grow up in the LDS church or faith?
No, we did not.
Did you know Charles to ever convert to the LDS faith?
He did at some point during his marriage to Lori.
Okay. When Lori and Charles were married, did they always live in one state, or did they move?
No, they They lived here in Phoenix, in the Phoenix area, Chandler, Gilbert. And then they moved to Hawaii in 2014, and then they moved back late 2016 or early 2017.
Back to,
Oh, back here to Phoenix area.
do you recall where they were, what state they were in when they met?
When Charles and Lori met, they
Yeah.
were in Texas.
Texas, okay. In 2018 and 19, you told us that Charles and JJ would come visit you and the family regularly.
Yes,
In March of 2018, did you have a member of your family pass away?
yes, my mother did in March of 18.
Did Charles come out for that?
Yes, he did. He was there for her services. Lori was not, and we felt like something was going on. Well, actually, my husband felt it before I did, and then when she didn't show for my mother's funeral, I just thought that was just appalling. It appalled me that she wouldn't even come to something like that with her husband.
What was your relationship like with Lori?
Because of the work I did, the company we owned, I was on the phone an extreme amount of time, all the time. So I really don't like to call people. I'm not a phone person. I'll text you all day long, but I really don't like to talk. And so Lori and I never really had a big phone relationship. It was a text here and there. But mostly Charles would keep me up to date as to, different things that were going on, or, what they were up to, or Charles would call. Yeah, Charles would call me mostly.
So it sounds like you weren't close with her.
When Lori and I were together, it was like we hadn't missed a minute. We just took up where we left off, and she's very outgoing, and she's very friendly and very easy to talk to, and so we got along rather well, and I loved her.
Okay. So continuing in 2018, do you recall seeing Charles and JJ coming out to visit you guys in October of 2018?
Yes,
What was that for?
just a weekend visit.
Okay. What about in November of 2018? Did you see Charles and JJ then?
We did. My husband and myself and my granddaughter, we went to Las Vegas, and Charles and JJ met us there for the Thanksgiving holiday weekend. I thought that was odd. He wasn't with his family. He said Lori was sick, or Tylee was sick, is what he told us, but he just wouldn't share what all was going on at that point. Then when he finally did, he unloaded it all.
So in 2018, did you have any idea there were any, let me say this, in 2018, did you have some concerns about their relationship?
Yes, it was, for him to come as often as they were coming, was odd, and he was just unsettled, and we knew something was going on, but he would never say. So he talked to us when he was ready.
When we get into 2019, did you start to see your brother more?
Yes.
First, without going into what Charles said, did you ever become aware finally that his marriage with Lori was in trouble?
Yes, I did.
in 2019, again, without going into what Charles said, did you ever believe that Charles was concerned for his safety?
Charles was absolutely concerned for his safety. Lori had sent me a text, I think it was on a Thursday, that she and Charles were fighting because because of some stuff she came up with, and that she and JJ and Tylee were at a hotel. Well, I guess Tylee was, I'm not sure. And because she didn't want to have any fighting, so they went to a hotel. And I came out. I knew Charles the next day. That's when she sent it to me. And then I just really I didn't call Charles. I knew he'd call me, and he sure enough did. And he was a mess. And so I flew out the next day out here to help him with JJ and just to come and talk to him and see what was going on. He was alone, and Lori's family turned their backs on him and JJ. Okay.
Let's just kind of break it all down.
All right.
Now, you got a lot that you remember. So you said that you got a text from Lori indicating that she and JJ and Tylee were at a hotel.
Mhm.
And then you said that Charles then called you maybe the next day,
Yeah,
and you came out here to Arizona.
yes.
When you came out here to Arizona, did you become aware at that point that there was a big problem now with their relationship?
There was a huge problem now with their relationship.
And during this time when you had come out here, do you remember approximately when that was?
Like the 1st of February of 2019, or the 2nd, it was right in there.
When you came out here, did you then speak with Charles about his concerns for his safety? Just yes or no?
About his what?
His concerns for his safety.
Oh, yes, absolutely.
That's just yes. Is this the time where, well, let me ask it this time. When you came out here, did you see Lori?
No,
When you came out here, did anyone know where Lori was?
no, nobody was talking about where she was. Nobody would tell Charles where she was.
So your brother was trying to find where she was?
Yes, he was.
Where was JJ at this time?
He was with Charles, and that's one of the reasons I came out was to help him with JJ, because he was quite a handful, and Charles was a mess. He was broken. He was a broken-hearted man.
So you come out here, Charles has JJ. Where's Tylee? Do you know?
She's, as far as we knew, she was staying at Lori's brother's. That's what we knew then.
Okay. Did you have any interaction with her?
No.
How long did Charles have JJ where he's looking for Lori and can't find her?
Well, that portion of the time was 58 days, and I knew how many days it was because every day Charles would say something. He would tell me.
So he was counting them.
He would count them.
Were you out here the whole time? What'd you do?
I could work remotely at the time, so I did stay out here a lot, often, but I would fly back. I was back and forth between Louisiana and here from February until the end of March, because at that point, we moved Charles to Houston.
Okay. So the end of March, you said you were moving Charles to Houston. Was that with JJ?
Yes.
Why was Charles going to be, why are you helping him move to Houston?
Because it was, Charles told me that Lori did not want JJ anymore, or Tylee, or him. And I said, okay, well, look, what if you move to Houston and I'll be 2.5 hours away, and when you go out of town, I'll come and stay with JJ. And so he was talking about hiring a nanny, and I said, no, I will be the nanny, and I'll come and take care of him when you have to work. And it's easy enough, and you won't have to pay a penny.
So when Charles has JJ, you're helping take care of JJ in this time period in February and March.
Yes.
What about Charles's business? Did you help with that at all?
Yes, I had to get my arms around the whole thing. All the payments that needed to be made, the accounts, the emails, all that stuff you have to change over and change the password and all that, so Lori couldn't access it any longer.
You said you had your own job. What were you doing at that time in addition to helping your brother?
My husband and I owned a coastal crew change. It was a transportation company for the offshore oil and gas and LNG industry.
Okay. So you're trying to work that job and help Charles with his business.
Yes, I had a really great assistant who helped me an awful lot.
Do you remember when you were packing up to move Charles to Houston?
Yes.
You there?
I was there.
Did Lori show back up?
She did. I was in the pantry in the kitchen, packing up the pantry, and I don't know what, just something caught my attention, and I walked out and she was standing there. She had her back to me. Charles was sitting at the table on his phone, and he obviously didn't realize that she was there. And then finally, when he hung up, he looked up and there she was, and he started crying, and she started yelling.
Do you recall what she was yelling about?
That, why did you take JJ? Why did you take JJ? Why did you take him out of school? Why are you moving? What are you doing? All this is your fault. It was just ridiculous.
So she'd been gone for 58 days, leaving.
No contact whatsoever.
And then she shows up at the house when you guys are moving out.
Yeah.
What was Charles's demeanor reaction? You said he was crying?
He was at first, but then he was just trying. Charles was a very soft-spoken man, and he was just trying to get a word in edgewise. And finally, Lori settled down a little bit, and they went and they talked for a while in the living room, or the I guess it's like a great room. And then they moved to the bedroom to talk. And I could still hear every now and then Lori would get a little loud, but they were talking. And then I remember that Lori came. Let's see, I was sitting at the dining table, and she stood next to me and she said, "I love you, KK." And I said, "Well, I love you too. I'm sorry this is happening." And she cried, and I didn't know what to do really. So, I mean, I just was there. And then she walked off, and the next day she came, I don't know who came, but they got Tylee's belongings out of the casita where all of Tylee's belongings were. And I don't remember if she got anything of hers. I really don't remember.
Okay. So are we now talking the beginning, end of March, beginning of April of 2019, when Charles is moving back to Houston.
Yes.
Did he bring JJ with him?
Yes. Well, in order for me and Charles to move in, Larry, I flew out here and brought JJ back to Louisiana with me. And then my husband, Larry, kept him for a week while I flew back here to help Charles pack and then drive back to Houston.
All right, so you guys rented a big truck and drove it?
He drove the U-Haul, I drove his pickup.
All right. When you and Charles got to Houston, then did your husband bring JJ back?
Yes, he did.
Through all of this time with Charles, when he was looking for Lori while she was gone for those 58 days, did he still want Lori to be part of JJ's life?
He did. He never was trying to take that away from Lori, even though Lori didn't want him anymore. I never really understood that, but I guess he was just hoping for the best. But yes, he absolutely wanted her to be part of his life, Lori's life.
So once Charles moved to Houston, did Lori ever also move out there?
I don't know if you call it moved out there, but she did. She came that day on March 28th. Charles said, "Look, we're moving to Houston. You're welcome to come. I'll fly you out Sunday." And she said, "No, I'm busy. I have a project," or something she was doing in Hawaii. She said, "It'll be about 2 weeks and I'll be in Houston." So whatever she did, she was gone for 2 more weeks. It was a total of 72 days, I believe, she was gone altogether. And then she was there. She and Tylee moved in at Charles's, and Charles said that she slept in JJ's room with him.
So the first 2 weeks when Charles and JJ are in Houston without Lori, were you ever there to help with JJ or Charles's business?
No, Lori was there.
I guess
JJ was.
before she moved there, the 2 weeks.
I think,
Or did
no,
you?
I had to go home for a little while, but Charles came like the weekend. And, so if I wasn't here, he was there.
Okay. So once you drove him there, you may have stayed to help him and then you went home.
Yeah.
And you weren't there when Lori came to Houston?
No.
You told us that you had been helping your brother with his business, and I think you'd said something about changing passwords.
Yeah,
Was that to different financial accounts?
right. Credit card, bank, stuff like that. Yeah, the password to Google, the password to,
All the things you use for business?
Yes,
And so when you started helping him, you had changed a lot of those passwords.
yes.
At some point, did you become aware that, or at some point, did Charles stop asking you to help him with the business?
He did, and that's when Lori came back.
Okay. Now, you said that your brother worked in annuities, right?
Yes,
Right, that last part of the time when you were working with him up through sort of the end of March, beginning of April, were you aware of Charles coming into a large amount of money?
he was receiving an annuity, what do you call it? I can't think of the word right now, but he was receiving like $125,000 check for his commission for annuities, and and Lori obviously knew that because she was there just a few days before that came into the bank, that was deposited into the bank. I had access to the bank, so I would watch that.
So even though Lori came back, you still had the passwords to look into Charles's account?
Yes.
Do you know how long Lori stayed in Texas with Charles?
It's like she wasn't there the entire time, but I mean, she was always traveling through May. I'll say towards the end of May. I'm not for sure exactly what day.
Okay. So at some point, a couple months later, you become aware that she has left Houston.
Yes.
Did you know where she went?
Yeah, she was back back here.
Did you know, did JJ come with her when she moved back here to Arizona?
He did.
And did you know, did your brother move back here?
No, he did not.
And with your access to the finances, were you aware whether or not Charles was paying for a house here in Arizona for Lori and JJ?
I really don't recall seeing that transaction. I really don't, but that, that doesn't mean it didn't happen. At that time, I was selling my company, and so I had a lot going on at that time, and that's when it was really getting, the due diligence. The company was doing their due diligence, so I had to provide a lot of information for them, and so it really was perfect timing because then I got super busy with my company, and I didn't have to deal with all of Charles's because Lori was back. Or
Let me ask you something else. Were you aware of when Charles met Lori, or they got married? Do you know if she worked?
she was a hairdresser. She did work as a hairdresser, and I don't know exactly when she quit working, but I don't think she worked long, if she did, after they got married.
Okay. So for most of the time when you knew them to be married, you did not see her working outside the home?
No.
Did Charles, I guess, work so she could stay home with the kids?
Yes, he was fine with being a one income, letting her stay home, tend to the kids, and he would be the moneymaker. Now,
I know that we've talked about Charles working in the area of financial planning. Did you know if Charles had a life insurance policy?
Yes.
That's something that, how did you learn about that?
Well, I mean, he had told my husband Larry and I years ago, he helped us acquire a $1 million life insurance policy for me and my husband each. And because he always had one, and Lori had one, so that was nothing new or unusual to talk about.
Okay. At some point when you were helping Charles, when Lori had disappeared and Charles didn't know where she was, did you have a conversation with Charles about the beneficiary of his life insurance?
Yes, it was early February when came here to help him with JJ, and he said, "Look, I'm going to take Lori off as beneficiary, and I'm going to put you as a beneficiary." And I was like, we talked about maybe a minute and a half about it, and I was like, okay, whatever. I really don't want to be that person, but okay. And I never followed up to see if he changed it. I didn't know until I got the phone call after he was killed.
So The discussion you had of that change was during that time period when he couldn't find Lori, had no idea where he was, and he was taking care of JJ?
Yes,
And you were helping him take care of JJ.
yes.
So if something had happened to Charles during that time when Lori wasn't around, would you have taken care of JJ?
Yes, he would have come back to me and my husband.
So I want to kind of go to right around that July time period. Do you recall when was the last time, I'll start with, when was the last time you saw your brother, Charles?
That's a good question. Probably must have been in June.
And do you recall where that was or the
I think he came to
circumstances?
Lake Charles for the weekend.
Did you see JJ then?
Yeah, no. The last time I saw JJ was May 18th.
When was the last time you recall speaking or texting with your brother, Charles?
He texted me the night before he was shot, and just, hey, I'm going to be in Phoenix tomorrow, and how's it going? And just a little short text, and I'm boarding the plane now, and I'll be back in Phoenix in a little bit. And then he told me a few other things he had planned, but that was not much, not a big deal.
Did
Nothing
you think
major.
he was going to Phoenix to just see JJ?
Yes.
Did you know anything about any type of intervention?
No, he never talked. If he did talk to me about it, and I'm pretty sure I would have remembered that. But no, I know that he and Adam was his confidant during that time, Lori's brother. And so I know that whatever he was doing, Adam was part of it. And, they were just, I knew he was in good hands with Adam, because Adam, they loved Charles, him and his wife.
Do you have any knowledge of Charles wanting to get a place here in Phoenix so he could be closer to JJ?
I don't remember that, but I can't remember that. I mean, I don't think, I don't know.
No,
I can't
okay,
answer that.
that's okay. I want to talk to you then about, so you talked to your brother, just kind of normal stuff as he was, before he got here to Phoenix. How did you learn that your brother Charles was dead?
It was on July the 12th. I was at a nail salon in Lake Charles, my granddaughter and I, and I got a call from his oldest son, Cole, and he said, "Hey, what is going on? I just got a text from Lori, and she said Dad's dead." And I said, wait, what did you just say? And he told me again, and I said, something's wrong with that. That can't be true. And I said, have you tried to call her? And Cole's like, yes, she won't. I'm trying calling, she's not answering. He was freaking out, and I was like, okay, Cole, just give me a minute. Let me think about this. Let me see, and I'll call you back. I promise, as soon as I can figure this out. So I called my husband to tell him, and he said, okay, well, I told him that what the Cole said, and he said, hey, let me call you back in a minute. And so I was still at the nail salon trying to get out of there, and he called and he said, he's dead. I Googled him, and he's dead. Alex killed him yesterday. And I mean, that was just like, it was horrible. I have to call my siblings and let them know. Thank you. And everybody was freaked out. I didn't know what to do. But I did call Cole back and let him know that it was true. And just was telling him, let's keep in touch. You find out something, I find out something, we'll let each other know. And
Did you try to reach out to Lori?
I've tried calling, texting Charles. I tried calling, texting Lori. And at some point, she texted me, she returned a text, something like, I'm having to deal with a lot of stuff and I'm busy. And she was too busy to even call his family to say that he was dead by her brother killing him. And
Take a breath. So you had tried to reach her and she was too busy to talk to you.
yeah.
Did you ever, what was the burial plans? Did you ever get Charles back? What happened with him?
We ended up calling a detective, the detectives in Chandler, since that's where it happened. And we were able to speak to a detective, I don't know who, but we told them that I had already arranged us a flight for the next day. We were here by noon Saturday because I needed to know I need to know where JJ was. I didn't know what he had seen. I didn't know what he knew. I knew he would be, I knew it wasn't good. But I couldn't, we had to talk to the detectives before I did anything with Lori. So, and we had to wait till Sunday to meet with Nate Moffett. And then when we talked to him is when I told him about the life insurance policy and that Lori, that I didn't know if Charles had ever changed it to me like he said he was going to do. And so I didn't know, but I just knew we had to get JJ because he was not safe with her.
Let me stop you there. I'm going to go back to Charles. Where was Charles buried, or where was what was done with his remains?
Well, this was before Lori knew she wasn't getting the money. She had him cremated and he was mailed, he was FedEx or whatever over to my office, along with his Letterman's jacket from high school and a couple pair of cheap sunglasses and 1 or 2 watches. It was just a few little trinkets. And Charles had a watch collection, and she just sent some crap.
So she cremated him and FedExed him to you.
Yes,
Sent him to your work office?
yes.
Now you're saying this is before she learned the life insurance policy was not going to be, she was not going to be the beneficiary. Did you set up like a service for Charles in?
Yes, my family and I made arrangements for a memorial service to happen in Lake Charles on August the 3rd, which was, he was killed July 11th. So it took us a little bit to put it together, but we did.
Did you talk to Lori about having JJ come out for Charles's service?
I think the last time I talked to Lori was, she told us that she wanted, I asked her, what can we do in Houston? I was trying to be nice because I knew she had something to do with his murder. And I'm not one that can just lie off the cuff. I'm a bad liar. And so when I did talk to her, and it was a long, awkward conversation I had with her, but I was like, what do you want us to do with that stuff at the house in Houston? But when we got to the house in Houston, and she did, yeah, y'all please go do what you want to do with it, see what Cole wants, y'all split it up, y'all take it.
She gave you permission to go to the
Yes.
house in Houston and take whatever was there?
Yes, and when we got there, none of Charles's personal belongings were there, nothing at all. And that, I couldn't figure out why nothing of Charles's or JJ's was there. Or wait, nothing of Charles's was there. Just his business files and the big furniture, sofa, beds, stuff like that.
So you went there, you did that. How did you, and you told us that you did not know for sure if your brother had ever changed the beneficiary from Lori to you. How did you find out if that was done?
I think it was the following week, a lady from Banner Life, that's where it's policy, who wrote the policy. A lady called and said that I was the beneficiary, I was the sole beneficiary, and what was our address, and she wanted to verify a few things and to send out the check.
When you got that call, did you ever have Lori confront you about the life insurance policy?
Did I ever have Lori what?
Yeah, did Lori ever confront you about being the beneficiary
Oh.
for Charles's life insurance policy?
Yes, she didn't call and do it. She sent me a text one night, a picture or two of a screenshot. She took a screenshot of the change of beneficiary form with my name on it. And she said something to the effect of 5 kids and his sister gets all the money, or is that why you want JJ? Something to that effect, which it made no sense. I want JJ, period. That was a dumb statement by her.
So let me ask you this. So she told you again that she was left with these 5 kids, right?
Yeah, 5 kids. She had Colby and Tylee and JJ. And
at that
Colby was
time-
out of the house, so it was just Tylee and JJ.
So she's messaging you this, saying how upset she is because she has 5 kids to take care of.
Yeah,
And then she tells you that, is this why you wanted JJ to come to Charles's service?
no, I had already gotten the okay from her to come get him. I was gonna fly here, pick him up, go back to Louisiana, keep him for a week and attend so he could attend the service during that time. And when she found out when she found the change of beneficiary form, she said that she was too busy. They were moving to Hawaii, and it would be too confusing for JJ to come, and he needed to be with her.
So after she found out and had confronted you about that change of beneficiary where you are now getting Charles's life insurance policy, she changed her mind and refused to let JJ go to Charles's service, his
Yes.
dad's service. After this confrontation about Charles making you the beneficiary of the life insurance policy, did that pretty much end most of the contact you had with Lori, other than you reaching out to talk with JJ?
Yes.
Thank you. I have no other questions.
All right, Cross?
Ms. Woodcock, where were you on July 11th, 2019?
At home in Lake Charles, Louisiana.
Were you aware at all of the relationship between Charles and Tylee?
It was, let's say, it was a bit contemptuous. It seemed like there was always a lot of drama going on, and so that's all I knew. He didn't say too much about it, and I didn't pry.
But you knew that there was some kind of contention going on with those two for
I
a
can't hear
while?
you.
I'm sorry. You did know that there was some kind of contention going on with those two for a while?
Yes.
Okay. And you weren't really aware of the events that happened that morning, were you?
The morning of his
July-
murder?
Of July 11th?
No, I wasn't.
Okay.
Because you didn't tell me.
Ms. Woodcock, did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Thank you. No further questions.
All right, redirect?
Just briefly. You were asked about the relationship between your brother and Tylee. How old was Tylee when Lori and Charles got married?
She was 3, or right around 3.
So was Charles in her life for most of her memorable years?
Exactly, yes, he was.
And how old was she in July of 2019?
She was 16. Yeah, yeah,
So teenager.
yes.
In terms of their relationship, are you saying that Charles and Tylee never had good times?
Oh, I'm not saying that. I saw them have good times, and it wasn't, it wasn't that they couldn't look at each other, or, it wasn't like that. But, I mean, yeah, a teenage girl on one is hard anyway, but I do know that there was a lot of issues with her dad and Lori with her ex-husband and custody, and it was a mess. It was a mess.
So Tylee had a lot going on in her life,
Yes, she did.
and you would see her and Charles at times have difficulty getting along.
I never really saw anything that sticks out in my mind. But I just know he'd tell me how it was just difficult. And as a step parent, it can be very difficult. I can attest to that.
So on July 11th, when Charles Vallow was killed, Did you actually have any idea that your brother was dead?
None at all. How would I know?
So, in terms of you learning that your brother was dead, it was never from Lori
Or
Vallow.
from her.
It was,
It was from Google that my husband found.
thank you. I have no other questions.
Are there any questions for this witness from anyone on the jury? I don't see any questions. You could step down, ma'am. Done. All right. Members of the jury, that's going to conclude trial for this week. No trial tomorrow. I'm going to try to start early on Monday and Tuesday only. So just to preview next week, I plan on, if you guys can all be here at 10 a.m., ready to start a little earlier than normal for Monday and Tuesday. And then Wednesday and Thursday, we'll be back to the 10:30 a.m. All right. I'll remind you to remember the admonition and avoid any sort of information about this case that you do not receive from this, that's outside of this courtroom, I should say. All right. Thank you. We'll be at recess.
All rise to the jury. Just checking, sorry. Just checking if they're gonna come up.
Is there anything from either the state or the defense?
No.
All right. We'll see you Monday morning.
See you Monday, Judge. Bye, Lori. See you Monday. Have a good weekend in jail. Enjoy it. So I have some quick thoughts about this. I think definitely Lori chickened out and asking questions to Kai. Kai did amazing, understand? Amazing. Loved it. I loved that she was not scared of Lori. About that question, Willow, I think Lori would have objected a lot about that coming in, so would probably not come in, but yes, it would have been a great question for sure. Yeah, I think so. Secretly Pickles, yeah. So, yeah, that is true. The past tense, yeah, definitely. This spoke a lot, and it was very clear that she spoke. Obviously, I know what a way to end a 3-day jury has 3 days to think. Definitely, even though they shouldn't really think yet, but definitely 3 days. But it's also 3 days that a lot of stuff can happen. We already lost 2 jurors this week, and it's only the first week of trial. But yeah. So it's just yeah, so I was just like, it's just very tempted to the 3 days, but yeah, so it's just crazy. We come back for Lori Monday at man, I forgot the new timing on. I think it's how 1:30 p.m. The new time. Does anyone know? Monday, yeah, but they come. Yeah, I think it's 1:30 p.m. Yes, 1:30 p.m. Eastern. Court starts. Yes, that is true because it's half an hour earlier than we are used to, but because of the half an hour delay. So yeah, Monday 1:30 p.m. Eastern. But I will set up the streams. The stream for Monday soon. I know it is working for me. It is awesome. I am so glad that it's working for you, Pickles. I'm so glad that we can have you a little bit more in chat. So yeah. Yeah, Willow says the past tense is how a lot of suspects give themselves away when asked questions by police. X person is missing and they will say they were a good person. That is actually true. That is very good point. Definitely. Yes, 10 a.m. Arizona time. 12:30 Central. I think that is 12:30 Central, I think. Don't quote me on that. Just yeah, YouTube will tell you. YouTube is better to tell than me. But yeah, so it's been an awesome day, very spicy day at court today. We've had some very, very good witnesses for this trial that I think even confirm the guiltiness of Lori. Is there anyone though that thinks Lori is not guilty? I know it's a dumb question, but it could have been. So, yeah, just so I definitely I am on 100% sure on the guilty side. There is no question about it. I'm just wondering where Denise is, because knowing that she's our expert of verdicts, I want to know. Sorry, I will look in a second. So, yeah. I, I don't know. There's people that could think, I don't know, pickles, people that have different opinions, and that is okay. And there's people that could think that she's not guilty. I don't know. Um, right here. Yeah, how expert, what do you think? Guilty or not guilty? You're welcome. Do not harm. I really appreciate having you here every day. Thank you. Um, I know, I know. It is scary to think that there's people that actually think that she is not guilty, because of all the evidences and everything. I absolutely understand that, friend, but it is the reality, sadly, sometimes when things. But that is okay. People have different opinions, and it's amazing, and that's why. Hey, Zio, is the food ready? I'm coming for food. So, I think we're gonna leave the stream here. Oh, she's. So then, guilty. I completely yes. See, our expert has spoken, so she's guilty. Our expert on verdict, has spoken. I'm coming for dinner, Zia. Then, but oh yeah, definitely. Our lies are catching up to her, and against my big knowing that she's already locked. Oh yeah, definitely. No matter what the result on this trial, she's already gonna be gone for life. So absolutely, never. Yeah. So. Oh yeah, no, definitely. You guys go. I am gonna go as well. Podcast is starting in about 5 minutes. I'm gonna get my headphones, go to bed to the warmth, and I enjoy it. And yeah, I'll see you all tomorrow, 9 a.m. Eastern. I'm gonna set up the stream as well. And I'll see you all tomorrow. Exactly, Denise. Our podcast in 8 minutes. Alright, I'll see you all tomorrow. Have a great day, evening, and a great weekend. If I don't see you tomorrow, I'll see you tomorrow. Bye guys.
And I'm a real-time crime professional.